make this Lashri, I beg to mention item number 2, Lashri. I am for the respondents, Lashri. Lashri, I am suffering from cough and fever.
There is a 2009 matter. 2009 matter, we are not adjourning. That's okay. Even if you don't assist us, we'll have to take it up. 2009 is no adjournment matter. No, that is okay. Even if you don't assist, we'll have to dispose it off. Second appeal, we are 2009, we are not keeping pending. After 2 days, there's vacation. So we'll take it up.
Second appeal, it was filed just last Saturday. Lordship permits me to move it tomorrow.
Give it to the all the mentioned was give it to the court master. We have to make some adjustments, but give it to the court master.
Lordship, I'd like to mention item number 23. Lordship, the senior counsel, Mr. H. Sharma is out of station. This matter may come up after vacation.
23, okay. List after vacation is paid for by the counsel for the appellant. Yes.
Lordship, I beg to mention item 31 and 32.
Item
31 and 32. I am for the petition in this case. We want to file the reply. Respondent 1 and 2 have filed the affidavit. Now I file the reply for
31 is containment FO.
Yes.
Well, let me take it up. You renew the prayer when the matter reaches.
We have taken consent of the respondent.
No, my lord, I am present here. Appeal is itself not maintainable. They have valued the appeal only ₹100.
No, that's
Also,
okay, but we'll take it up.
Yes, sir.
You renew the prayer when the matter reaches.
Yes, sir.
File here.
Mention item number 13, 13.
1-3.
Matter may be withdrawn, my lord. The same matter was earlier disposed of, for which I was not aware of the fact, my lord.
Okay. You've informed the other side.
No, I am the petitioner.
Okay. Okay, I'm making a note of it, but I'll pass orders when the counsel is present. You may not be here.
Lordship, I beg to mention in respect of item number 11, Lordship, we seek item number 11, Lordship, of the release.
Yes.
We petitioner seeks to withdraw this matter since the dispute has been resolved. Lordship.
Suit has been withdrawn.
We want to withdraw this.
Okay, okay.
Withdraw this
Your name?
Ad hoc, Lordship, on behalf of P. Dekar. My name is not shown in the court books.
On behalf of
Mr. Pinat Dekar, P. Dekar, Lordship.
item number 11.
11.
11 has Mr. M.A. Islam and J.I. Mandal here.
I'm extremely sorry. I'm mistaken. I'm extremely sorry. This is another good. I'm sorry.
Okay, okay. No issue. No issue. No issue. No issue.
The case MSc appeal, my lord, in
Hmm.
admission column.
Mention to the court master.
Top of the list, item 1.
For a long time, the matter has come back to this court. Lordship would probably not.
I don't know. I don't know whether you are happy or not
My lord.
that it has come up at the top of the list. I don't know whether you are happy or not.
All the matters, my lord, should come
We
up
want everything to be on the top of the list.
Huh?
Lawyers want everything to be on the top of the list. This matter, Lordship, was heard initially, but then while reserving it for orders, your Lordship has made an observation thereafter that one particular issue that appellate court did not consider was that there were 3 plaintiffs, and the appeal was filed against only one of the plaintiffs. The 2 minor children who were the beneficiaries of the policy, my lord, they were not neither party. So in fact, on 19/12/2019, Lordship had passed an order making that particular observation. And my lord, the matter was otherwise released from Padhat, but because of COVID thereafter, this thing did not take place. Look at the order, because before going on to the
Regarding
other
non-general
matters,
necessary party.
my
I
lord,
repeat, huh?
on 19th, Lordship
Yes,
has made an
I have seen
observation.
that.
That is there in the order. Before addressing that, my lord, yes, it is a fact, my lord, that there were.
So the
three
order,
persons,
order against those two plaintiffs had become final.
my lord. That is one way of looking into the matter, my lord. But then the only route I have, my lord, now is to look into the provision of Order 41, Rule 4, my lord.
Order 41, Rule 4.
Order 41, Rule 4.
CPC. CPC. Yes.
My lord. One of several plaintiffs or defendants may obtain reversal of the whole decree where it proceeds on grounds common to all. Where there are more plaintiffs or more defendants than one in a suit, and the degree appeal from proceeds on any ground common to all the plaintiffs or all the defendants. Any one of the plaintiffs or the defendants may appeal from the whole degree, and thereupon the appellate court may reverse or vary the degree in favor of all the plaintiffs or defendants as the case may be. My lord. So the language is, my lord, here is a case of
No,
horizontal.
this applies to the appellant.
My lord.
You see, let us say in a case there are two defendants. So one is aggrieved. He can file an appeal. There is no issue with that under 4. But to file an appeal against the plaintiffs who have obtained a common decree, that is something which is still under Rule 4 is not acceptable. But then somebody is being decree is being interfered with without hearing them, without notice to them. Now let us say in this case, there are two plaintiffs, 1 and 2. There's a common decree, joint decree rather, against both of them. Now, this is a reported case, that's why I'm saying so. And now one of the plaintiff and one of the defendant enter into a compromise. That you will find is a case of India Umbrella Manufacturing Company. So what happened was that there was a suit proceeding going on against ejectment of a landlord and tenant. And one of the tenant purchased the share of one of section of the landlord. So now what happens is that the tenant becomes landlord for all. They mingle into the shoes of the tenant as well as the landlord. So therefore, the issue was raised that now the ejectment cannot take place because he is also the landlord, he is also a tenant. The matter traveled from here to Supreme Court, and in Supreme Court it was held that no. Under 142, what the Supreme Court did was that the share of the defendant tenant was culled out, and a decree was passed, saying that the land is divided, because this is something very unique that the Supreme Court did, was a case arising out of Guwahati. So that's why I'm asking you. Now, can a reversal of a decree take place in absence of one defendant? Let us say in this case where there was a compromise between the parties. So appeal is filed. That appellant, who is really the contesting appellant now, does not know about it.
Compromise will definitely not find
No,
out.
I'm just giving an example because this has happened. I have read this case. That's why I'm just telling you. I may have given you a different example, but since this is a case which I have read, that's why I'm giving you this example, which is there in my mind. So you see, the interest of the plaintiffs may differ after getting the decree. So can one be condemned without being heard?
Definitely. But then here is a case, my lord, the question of interest of the plaintiffs being different would not arise. Here, basically, it's a issue of insurance policy, which the legal heirs will undertake on their receipt. So legal heirs are the wife and the 2 minor children. At that point of time, they were minor, now they have attained majority.
No,
So now-
then you see, because here there is an issue. Once you are referring to this, if the court finds that a minor's interest is involved and the minor is not represented by its legal representative, then this suit is required to be struck off.
Right.
That is minority is order 32, I think. No,
This order,
minority is which order 32.
Yes, my lord.
Huh?
Order 32, my
32. Suits,
32.
by or against minor.
Huh.
The original suit might not the minors were there.
No, it's okay, but in the appeal.
They were joint and they were represented by the mother.
Yes, but in the appeal. 31 rule 2, where a suit is instituted without next friend, plaintiff to be taken off the file. So that is the prescription. So under that circumstances, why non-gender would not be fatal to a minor? I think last time, I now remember, really it's come to the mind, but at that point of time also, we did not find any answer to this. We did not find any answer what happens to an appeal. Because this order 41 rule 4, which we are referring to, it does not,
Yeah, the language is slightly different than the fact circumstances here.
no, that's okay, but order, I'll show you this. This order 41 rule 4 has not been interpreted, that even if there is a joint decree,
Yes. The other decisions I could find, my lord, was kind of the example lordship was given. In some cases where we have come in the paper, one of the defendants might come and obtain a reversal against the others. But then whether if they are not leader party, what will happen? That is not answered.
no, because the decree against the minor becomes final, that decree can't be taken away. So even if you succeed otherwise, that appeal will have to be said that that appeal would stand. Sorry, that decree against the minor would stand. Because we are not, in the absence of the party, we are not required to make any observations so far as that is concerned. So it doesn't help you anyway.
I have probably, my lord, argued, if I recollect also, my lord, at that point of time, that being in the insurance policy, my lord, the payment that we are supposed to make to the decree is, my lord, in favor of all three. The nominee is the one to whose account we will transfer the money. That is the mother, my lord. Thereafter, the apportionment would take place between them. It's a different thing.
No, I don't know, because
my
I
lord,
have-
we would know only the nominee and the nominee's account, my lord.
No,
We
I don't
transfer it
know.
to-
Even when I was there and when I'm here,
my lord.
I found cases where the family members, the mother and the son, are in quarrel.
My lord, may I interfere, my lord? 1984 Supreme Court says that.
No, you want to submit or you want to interfere?
No, no, no. Sorry.
No, you can submit, no problem. Interference we may not allow, but submission will allow.
My lord, let me.
The learned
No, no.
counsel's, my lord, wisdom is very much required.
No, please address. Please address. I just like to smile. I got an opportunity and I,
In my lord, LIC case itself, my lord, in the year 1984, Supreme Court. Yes, nominee regarding nominee. That nominee does not take away the right of the heirs.
no, that is true. He's also submitting same thing. He's saying that it will could be transferred to the account of the nominee and nominee can apportion. So
Yes.
therefore the court has the power to apportion the degree. One will be the recipient because the LIC after the nominee is registered will acknowledge only the presence of the nominee. So that is true. That we have no difficulty.
I'm not going to interfere.
This is the issue in which we require my lord some deliberation. Otherwise, I could not find any legal precedent, my lord, of this kind.
No, even this never came to my notice.
One other decision, my lord, that I could come across, my lord, recently by
Because this order 41 rule 4 has been interpreted by the Supreme Court in the case of Asghar Barid.
Asghar Barid, my lord, that is what I was
Huh.
about to submit, my lord.
So that merely says that the Supreme Court can grant relief to a non-appealing appellant. It doesn't say that the relief can be granted when a plaintiff, co-plaintiff, not being impleaded.
But then, order 41 rule 4 is read with order 41 rule 33, here, my lord.
Yes.
33, my lord, probably some answer, my lord, if we can try to get from order 41 rule 53, my lord. And of course, yes, the question of being a party and not being neither party is still not very clear from this particular provision. It says, my lord, the appellate court shall have power to pass any decree and make any order which ought to have been passed or made and to pass and make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is to a part only of the decree and may be exercised in favor of all or any.
No,
of
this
the
is only the
respondents or
enabling power.
parties.
Because otherwise, if this order 41 rule 33 was not there, you would have asked the appellate court power to pass a decree.
My lord.
Because reversal is okay or affirming is okay, but where is the power of the court to pass a decree? So therefore, this 33 says that you have a power to do whatever is to be done.
Right.
So therefore, read with 4.
So read with 4, my lord, it says that if somebody is not there as a appellant also, in that case, you can reverse a decree or pass a decree.
So we are dismissing this.
My lord, I will only submit that, my lord, the corollary has to be drawn, my lord, from.
I'll make a note of that
My lord.
submission. Yes.
Once it is going to be dismissed, my lord, nothing to say more.
No, no, Mr. Sattar, not that. Because Mr. Pathak is right. In these cases where there is no law which is settled on the point, there your assistance would be required. Because nobody wants a wrong law to be penned down. Whether you win or lose is not a matter. Even you would not want the incorrect decision to come on record.
Definitely. Asghar Barid, Lordship.
That I have. That I have. Heard. Mr. B. Pathak, learned counsel for the appellants, and Mr. A. Sattar, learned counsel appearing for the sole respondent. This appeal under section 100 CPC, which is directed against which is preferred against the judgment and order dated 25/2/2009, passed by the Learned District Judge Morigaon in title appeal number 2 of 2007, arising out of judgment and decree dated 5/2/2005, passed by the Learned Civil Judge within bracket Senior Division bracket close Morigaon in title suit number 15 of 2003. This appeal was not admitted. This was not admitted for hearing.
Madam, I could not find today, madam, the original. The orders passed in 2009, I could not find, madam.
Oh, yes, it is there.
No, it's in the end.
Was admitted for hearing.
I think on
On the-
8/6/2009.
No, it is 10/6/2009. Admitted for hearing by order dated 10/6/2009 on the following substantial questions of law. Full stop. Next para. The facts relating to the decree passed by the Learned Trial Court is that a suit for declaration and recovery of insured amount due on the insurance policy number 48222321 was filed by the respondent along with her two minor children who were arraigned as plaintiff number 2 and 3 respectively. The predecessor in interest of the plaintiffs had taken two LIC policies for rupees 2 lakh and rupees 3 lakh respectively. And while the policy was in force, he died on 19/5/1999. Living behind the plaintiffs and two pro forma defendants as his legal representatives. Stop. the claim made by the plaintiffs was rejected by the appellants on the ground that the previous policy was not mentioned in the proposal of insurance dated 27/2/1999. Full stop. The other ground for rejection of the claim was that the predecessor of the plaintiffs had died of, was suffering from heart ailment since a long time, which was not disclosed in the prescribed form. And he died of a heart attack. And accordingly, the appellants, as defendants, contested the suit and prayed for dismissal of the suit with cost. Next paragraph. In course of trial, the 4 issues were framed. 4 following issues were framed. Page 28, flag. So, in respect of issue numbers 1, 2, and 3, the said issues were decided in the affirmative and in favor of the plaintiffs. In respect of issue number 4, the plea of the appellants was not found acceptable. Because in the relevant column 8 and 9, the same was not filled up and shown as inverted commas, no inverted comma closed, and inverted commas nil, NIL, inverted comma closed. And accordingly, as the LIC had accepted the policy as well as the premium, the appellants was found liable to pay the insurance amount of rupees 3 lakh and accordingly the suit was decreed for the said sum along with interest at the rate of 10%. And by framing and sorry, it will be 5 issues, not 4. And the issue number 5 was to the effect that the plaintiffs were entitled to the decree. And accordingly, the suit was decreed as indicated above. Next paragraph. The appellants preferred an appeal under section 90, under section 96 CPC against the judgment and decree passed by the learned civil judge within bracket senior division bracket close Morigaon in TS 15 of 2003. So the so it appears that the London First Appellate Court had not framed any point of determination to stop. However, the issues framed by the London trial court were revisited by the London First Appellate Court to stop. The evidence was reappreciated and all the issues were once again decided in favor of the plaintiffs and against the appellant, and accordingly the appeal was held to be devoid of any merit and the same was dismissed by the London District Judge Morigaon in TA number 2 of 2007. Full stop. Next paragraph. The aggrieved appellants have filed this appeal under section 100 CPC, read with other yes, 100 CPC. Full stop. As already indicated above, comma, the appeal was admitted for hearing by formulating substantial questions of law as referred above. Full stop. In course of hearing, on the order dated 19/12/2019, the court having found that although there were 3 plaintiffs in the suit, in the first appeal as well as in this second appeal, only the plaintiff number 1 was arraigned as the sole respondent, and that the plaintiff numbers 2 and 3, who were then minors, were not arraigned as parties either in the as respondents either in the first appeal or in this second appeal, and accordingly the court, while directing the matter to be listed for hearing, had indicated in the order that the learned counsel for the appellant would answer the query of the court regarding non-joinder of necessary parties. Next paragraph. The learned counsel for the appellant has submitted that as the first appeal was decided in the absence of the plaintiff numbers 2 and 3, there was no necessity to implead. They said respondents in this appeal. Full stop. Moreover, it is submitted that as per the LIC policy, the registered nominee was the respondent, was the mother of the plaintiff numbers 2 and 3, who were at that point of time were minors. So accordingly, it is submitted that the interest of the minors would be taken care of by the sole respondent, who is only and who is the nominee, and therefore any degree passed in favor of the or against the plaintiff number 1 in this second appellate proceedings, would naturally bind the respondent numbers 2 and 3. Next, thirdly, it has been submitted that in view of the provisions of Rule 4 of Order 41 CPC, it was permissible to have to challenge the decree in the absence of all the plaintiffs or the defendants, and accordingly they submitted that the appeal, the present appeal, would not be bad for non-general plaintiffs number 2 and 3. Full stop. In support of his submissions on the third point, the Honorable Counsel for the appellant has placed reliance on the case of Asghar, AZGAR, Barid, BARID, dead by LRS, small s, versus Mazambi, MAZAMBI, alias PRMB, PYAREMABI, within bracket 2022, 0 Supreme, within bracket SC, bracket goes 155, equivalent to EIR 2022 SC 1304. Next paragraph. The next for the age of the plaintiff numbers 2 and 3 is not known. First off, nonetheless, the husband of the but their predecessor in interest had died on 19/5,
1999.
1999,
Yes, ma'am.
and the suit was filed on 9/7/2003. First off, in all probability, the in 1993, first off, we first off, in the plaint, the prayer was for passing a decree for recovery of the insured amount of rupees 3 lakh against insurance policy number 48222321 with interest at the rate of 18% per annum. First off, the said suit was decreed for an amount of rupees 3 lakh as paid for, however, with interest at the rate of 10%. First off, the learned trial court had not passed the decree only in favor of the sole respondent, but the decree is joint and it was jointly and severally filed, passed in favor of all the three plaintiffs. First off, therefore, in the considered opinion of the court, even if the decree, the decree passed against the sole respondent fails for some reason, the decree which has been passed in favor of the plaintiffs number 2 and 3, having not been challenged, has become has become perfected by a flux of time, because by now the limitation for assailing the said decree has already expired, and moreover the expired full stop. Next paragraph. Moreover, insofar as the proceedings, the appellate proceedings before the learned first appellate court is concerned, the challenge being made only against the decree of the sole respondent, the same principle would follow, and that the decree insofar as the respondent, the plaintiffs number 2 and 3 are concerned, has remained unassailed. Therefore, that part of the decree having not been assailed even before the learned first appellate court, part of the decree, the decree insofar as the sole respondent is concerned, would not be maintainable, either in facts or in law. Full stop. Next paragraph. According to as the decree passed against the plaintiffs number 2 and 3 for a sum of rupees 3 lakh with 10% interest has been perfected without any challenge to the same, the present appeal also is also hit, is found to be hit by non-general or necessary parties, because in the absence of the plaintiff numbers 2 and 3, the challenge by the appellants against the concurrent finding of both the learned courts below would not be maintainable. First. Next para. The submission of the learned counsel for the appellant was that the respondent, the sole respondent being the mother and natural guardian of plaintiff numbers 2 and 3, and therefore the interest of of both the plaintiff numbers 2 and 3 would be adequately taken care of by the mother, i.e. the sole respondent. Appears to be attractive, but the factual matrix is to the effect that the decree in respect of the minor children have become absolute and perfected without any challenge. Full stop. There is no material on record in the evidence. There is no evidence on record that the let's strike that out. Last line. Strike. Full stop. So in the present case, the respondent is contesting the appeal, and it is not a case that the respondent has agreed to a waiver of the decree for herself and in favor of the and also in respect of her 2 minor children, i.e. plaintiff number 2 and 3, the court is unable to accept that the sole respondent would be legally authorized to represent the interest of the plaintiff numbers 2 and 3, who are not erased as the co-respondents in this case. Full stop. Next paragraph. One of the submissions made by the learned counsel for the appellant was that, what was the second point I formulated? I forgot. Three arguments.
That was, my lord, on order 32.
No, when I was dictating the second point, I have recorded these 3 submissions. Partial amnesia.
The nominee probably.
Huh?
As a nominee, he would receive an.
Nominee. Right. It's okay. Thank you for reminding me. The one of the submissions of the learned counsel was that the LIC also only recognizes the sole respondent because she's the only nominee of the LIC policy, and therefore the interest of the plaintiff number 2 and 3 would not be adversely affected if the appeal is decided qua the sole respondent, who is the plaintiff number 1, and being the nominee, would be otherwise having power to distribute the proceeds of the decree with plaintiffs number 2 and 3. Full stop. In this case, comma, the right of the nominee to receive the LIC proceeds, proceeds is not in question. Full stop. The plaintiffs number 2 and 3 had joined as their mother, the plaintiff number 1, plaintiff number 1 oblique sole respondent, as co-plaintiffs, and had obtained a decree. Full stop. The right of a decree holder cannot be accepted to be subjected to the prevailing right of the nominee of a LIC policy. Full stop. Therefore, the said contention of the learned counsel for the appellant is also not acceptable, as the right of the plaintiff number 2 and 3 has been fructified in form of a decree. Next, third, insofar as the provision of Order 41 Rule 4 CPC is concerned, comma, the said provision of law merely enables any joint plaintiff or the defendant, any co-plaintiff or defendant, to prefer an appeal independently, and the court would have power to interfere with the decree or affirm it only at the instance of either one of the co-plaintiffs or the co-defendants. However, the said provision cannot be read to mean as if the co-plaintiff or the co-defendant who has, whoever the decree has been passed, is not a necessary party in the appellate proceedings. Stop. Merely because more than one person has joined as plaintiffs or defendants, comma, it does not make the other co-plaintiff or the co-defendant an agent of the other co-plaintiff or the co-defendant. Stop. Therefore, comma, the sole respondent, not being a recognized agent or power of attorney holder in respect of her minor children, comma, plaintiffs number 2 and 3, and she is not being representing them either in this suit or in this or in the appeal or in the first appeal or before this second appellate court as in a representative capacity for them, comma, the said plea of the learned counsel for the appellant also does not hold good. Full stop. The case of Asghar, AZGAR, Barid, BARID, within bracket Supra, is also not an authority on the point that co-plaintiff or co-defendant is not a necessary party in the appellate proceedings. To stop. Next paragraph. In view of above, comma, in view of discussions above, comma, the court finds that the present appellate proceeding is bad for non-general plaintiffs number 2 and 3 as necessary parties, as the decree obtained in their favor has attained finality without any challenge to the same, either in the first appellate court or before this second appellate court. Next paragraph. Therefore, comma, the court does not find any necessity to decide any of the
Sense of law that are there.
no, because I'll refer to it now. The three substantial questions of law as formulated by order dated 10/6/2009 in view of the fact that the decree against the plaintiff numbers 2 and 3 has attained finality. Next, but according to this appeal fails and the same is dismissed. First off, the judgment and decree passed by the concurrent judgment and decree passed by the learned courts below stands affirmed. Next paragraph. Let the appellate decree be prepared. Next paragraph. In the meanwhile, the registry shall send back the LCR to the respective courts below. First of all, the parties are left to bear their own cost. In this case, disposed of 1
There was some deposit.
1429. Yes.
That was, I think, for stay some deposit.
Ah.
was made.
No, because I have to formally close it, otherwise it remains.
Yes, yes.
Top of the list, item 2.
Plaintiff appellant.
Just a moment. Just give me 2 minutes. This, what is this exhibit 2?
Is my lord a photocopy?
Landholding certificate. It's a landholding certificate.
It was not proved by either calling the records or the officers or by producing the. My lord, I am not on that, my lord. What I want to place here, my lord, regarding the complaint, my lord, there was a prayer for peaceful position. For peaceful position, because I hold that I am in possession of the land. Maybe on 3 counts I have stated. One is I claim as a rayati. One I claim that I paid verbally some amount in advance, and my lord, also in advance position. My lord, regarding physical position, my lord, if I am in physical position of a land, until unless they file a suit to dispossess me, can I be illegally dispossessed from the land? My lord, on deciding issue number 5, my lord, the trial court held that I claimed it as a rayati, and the person Adhiya told that he was a tenant, subtenant under me under the 71 Act, and my lord, from 2001. From the evidence I find, my lord, it was from since 1990. If I can take your lordship, subject to correction, my lord. Your lordship may turn to the issue
Evidence of PW2, 1990.
PW1.
PW2 says
My lord,
Yes,
Arjun Chauhan is PW1.
Deepak Bhatto.
But my Adhyar was Arjun Chauhan, PW1. That issue number 5. Issue number 5 is at page 36. Last paragraph,
Just on page
36.
36.
last paragraph.
Plaintiff number 3, PW3.
Last, the
Says that-
PW stated some fact on affidavit, but in cross PW once year, June Chauhan, he clearly stated that the plaintiff gave him the land for Adi in 2001. And before that, he do not know. But in evidence, my lord, I find in Wonderful and others, he claimed that he was Adi since 1990. And the appellate court, while deciding the point for determination, held that, my lord, in issue number 5, at page.
But that's not the substantial question of law on which the
that
appeal was
not
admitted.
framed, my lord. That was not framed.
So we can't go into that. Whatever is not there, we can't adjudicate.
My lord, the substantial questions of law was regarding the public document, whether it was exhibit to onus of proof lies on me, or the equivalent code order 20 rule 41 and prima facie and the 114 of the evidence act. And the appellate court, while deciding that, my only allowed submission that I can place. And in page 49, the appellate court, while deciding issue number 5, started with the conception that I claim position as a Rayati partner. But my claim says that I claim it as a from adverse position. And Rayati also, there is no evidence as stated, but Rayati can be under the act, implied also.
But you see, order provides you to order 18 rule 4. Just check that.
Just now your lordship was discussing on order 18 rule 4, that if there is no relief claim for
No. That is 41.
40,
This is order
18 rule 4.
order 18 rule 4 proviso.
Provided rule 4 provided that where documents are filed and parties rely upon documents, the proof and admissibility of such documents which are filed shall be subject to the orders of the court.
So therefore, when an evidence is introduced and a document according to you is not admissible, objection has to be raised. Because now under affidavit, when it is filed, there is no scope for objection when the evidence is introduced. But in either in cross-examination or by filing a petition before the court, an objection as to the admissibility has to be raised. Here, was it done?
I think that was it was decided in such that nobody was called from the office, and that was issue number, my lord. Position. Page 37. Page 37,
Mhm.
last but one paragraph.
What does it say, Mr.
While
Rajouri?
exhibit 2, a certificate has been produced from the office of the assistant central officer that the name of the plaintiff is there in the draft chitta as a rayati in defendant of the defendant number 1. The name has been denied by the defendants in their written statement. The certificate is only for the draft chitta, and moreover, for further proof, the same was not called for, nor any official of the office has been examined. They have denied in the written statement. Hence, I find the plaintiff could not prove that he is in possession of the suit land. Accordingly, I decide in negative.
Page 37.
7, last but one paragraph.
So the suit was dismissed.
Suit was dismissed, appeal was dismissed, concurrent finding. The appellate court, while deciding issue number 5,
But then you see this appeal, what you call, when that finding is not against you. So the appeal is an infructuous appeal which you are fighting. Because by now you have perfected your title. That is the only advantage you get out of this appeal. We don't give any finding, we close it. With this, what you call,
but with regard to position, the lordship can say something.
here the operation is unsuspectful and the patient is alive.
Hell, only my query was about my lord, the position, my lord, because if I am in position, your lordship.
You remain,
You
but we
remain
don't have to give any finding against that. Your position is there.
My lord.
There's nothing in it. We are dismissing it. You have any objection? No, he was seeking time, but I disallowed.
He called me today morning.
I disallowed because 2009 matters to keep it pending. Very difficult. Had Mr. P.K. Roy Chaudhary, learned counsel for the appellant, and Mr. R. Islam, learned counsel for the respondent. Next paragraph. You know, why I had to ask you a name? I'll show you this. Mistake. So you see, your gender was changed. No, it's okay. Don't do it. Don't do it. Don't do it. Because we are correcting in the order, but this is something we'll not touch. Next paragraph. this appeal under section 100 CPC is preferred against the appellate judgment and decree dated 27/6/2008 passed by the learned civil judge Kokrajhar in TA number 4 of 2007, thereby affirming the judgment and decree dated 27/2/2007 passed by the learned Munsif Kokrajhar in TS number 3 of 2003, thereby dismissing the suit. First of all, the appellant is the plaintiff. Next paragraph. The appeal, this appeal has been admitted for hearing by order dated 1/7/2009 on the following substantial questions of law. The case of the appellant plaintiff is that at the relevant point of time, she was a muster roll worker in the police court, Kokrajhar. What is police court? It's PPI office, prosecuting inspector's office, Kokrajhar. She claimed that the respondent number 1, who was the owner of the land, a suit land, had received an advance of rupees 3,000 as advance in the year 1990. For selling 3 bigha land out of his total land holding at a total consideration of rupees 15,000 and delivered possession of the said part of the land to the appellant. First off, it is claimed that at the set time, she could not pay the entire amount, and therefore in 3 installments of rupees 5,000, 4,000 and 3,000 respectively, sum of rupees 12,000 was paid to the respondent number 1 during the lifetime of his mother. First. So it was agreed that the name of the appellant would be recorded in the chitta in respect of the said land maintained by the revenue authorities at Gosaikom Revenue Circle. Full stop. It is claimed that the entry of the appellant was not made in the revenue records. But she has been cultivating this land as a riot. And her name was reflected in the record of rights as a riot with the respondent number 1. And it is also claimed that the appellant has been paying the land revenue in respect to the said land. As the name of the appellant was not recorded in the chitta as an owner, and as the respondents were trying to forcibly dispossess the appellant from the suit land on 14/12/2002, the appellant had lodged an FIR with Tulshi Bil, TULSHIBIL outpost, which was registered as Gosaigaon PS case number 210/2002. Stop. It is also projected that on 20/12/2002, the respondent number 1 executed a general power of attorney in respect of the said land of the entire land measuring 9 bighas, 15 dachas, covered by that number 47/49 of PP number 26/1 in favor of defendant number 3. Son of defendant number, the son of respondent number 2. And on obtaining a certified copy of the said power of attorney on 7/1/2003, claiming that the appellant was in possession of the land and maybe disposes therefrom, had filed the suit for declaring her right title and interest over the suit land described in the schedule of the plaintiff, for a declaration to hold and possess the suit land as a riot, and is entitled to get Rayati Patta for declaring the power of attorney dated 20/12/2002 as null and void and not effective, and for permanent injunction and cost. First of the said suit was registered as TS number 3/2003. First of the respondents the WS is by only respondent number 1. WS is by respondent number 1. 2, 3, and 4 have not. So it appears
Lordship, written statement of the defendants.
No, it is signed only by one. And there it is not stated that she is signing for others. That is why I have to look at it.
26.
Okay, all the defendants, all the defendants contested the suit. They're filing a joint written statement, which was verified only by the respondent of one. Full stop. The contention of the appellant plaintiff was denied. And it was stated that the appellant did not have possession of the suit land. And that the name of the appellant was entered in the revenue records as Rayat illegally, which did not confer any right on her. And accordingly, it was stated that the appellant had no right to deny the right title in interest of the respondent number one, or in respect of the other respondents. And it was claimed that the appellant was not entitled to any relief in the suit. Full stop. In course of trial, the following issues were framed for trial. Page 30.
If I can please query on one regarding Rayati, it can be implied. If no one evidence is there that
No, I'll not say anything in this case. You see, the reason being that if our entry of Rayat has to be challenged, there is a different forum. So under the land revenue regulation, the suit will the such declaration is not to be given by a civil court. So why should the second appellate court deal with it?
under the 71 Act.
No, whatever be, there's a provision where it has to be dealt with. If there's an entry, whether legal or illegal, has to be before an appropriate authority. So we will not make any mention.
That will be by the revenue authorities. Regarding Rayati and others. will be dealt
You
with.
know more than me. So why should I, as a second appellate court, deal with that issue? That's not even raised against that finding of possession and the Rayati entry. The appellant did not file a cross appeal
Well, they-
for expunging of that.
The respondent.
Her respondent has not filed an appeal. Cross appeal is not there. So that finding, you know how to deal with it. Next, in respect of respondent number one, issue number one. Common. The Learned Trial Court held that the suit was maintainable in its present form and appropriate court fees was paid. In respect of respondent, issue number two. The Learned Trial Court, on examining the evidence of the How many witnesses were examined? Three for the plaintiff
They produced no.
and for defendants? No, no evidence. Okay. The evidence of three PWs.
Did not reduce any evidence or witness. Page 31.
Come on, relied on the evidence on affidavit and cross-examination of PW3. By holding that the stand of the appellant within bracket PW3 was opposite to that made in the plaint. First of it was held that in the plaint and evidence on affidavit, the appellant had stated that the respondent number one had refused to give consent in writing in the chitta and other documents. And in the cross-examinations, it was stated that the respondent number one had signed the chitta and other documents in front of the SDC. And the land has been mutated in a name. Full stop. Considering both the stand, it was held that the appellant could not prove the sale and purchase, as she could not produce any document or copy of chitta to show that the respondent number one had given consent. Full stop. On the ground that the sale of an immovable property having value of more than 100 rupees is required to be compulsorily registered. It was held that the appellant could not prove that she had purchased this woodland from the respondent number one, and accordingly the issue was decided in the negative and against the appellant. Full stop. In respect of issue number 3, as the appellant claimed status of riot, the court found it unacceptable that the ownership right could be claimed by the appellant as a riot or through adverse possession. And accordingly, the issue number 3 was also decided in the negative and against the appellant. Stop. In respect of respondent number 4, the court expressed his opinion that the appellant could not cite any reasons as to why the general power of attorney executed in favor of the respondent number 3 was not void and illegal. And accordingly, the said issue was also decided in the negative and against the appellant. Stop. In respect of respondent issue number 5, Or the learned trial court relied on the cross-examination of PW1, namely Arjun Chauhan, ARJUN Chauhan, wherein he had stated that the appellant gave him the land for Adi in 2001. And that for the period earlier, he did not know. And had also stated that the appellant had never cultivated the suit land herself, as she was a lady. Full stop. Although the appellant had stated that she was in possession of the land since 1990 by cultivating it through her Adhyar, ADHIAR, Sri Arjun Chauhan. But as per evidence of PW1, Arjun Chauhan, it was revealed that the appellant had given the land to him in 2001. And accordingly, notwithstanding the certificate produced from the office of the assistant settlement officer within bracket exhibit 2, that the name of the appellant is there in the draft chitta as a riot of defendant number 1. The said certificate was disbelieved at the same was not proved through any official of the office of the assistant settlement officer, and accordingly it was held that the appellant could not prove that she was in possession of the suit land. Full stop. In respect of issue number 7, first, as the appellant could not prove issue number 2, 3, and 5. Accordingly, it was held that there was no cause of action for the suit, and the said issue was decided in the negative. Full stop. Resultantly, in respect of issue number 6, as the issue numbers 2, 3, 4, and 5 were decided in the negative and against the appellant, the suit was dismissed. Full stop. Next para, agreed by the judgment and decree. Dated 27/2/2007. Passed in case 3 of (2003). The appellant preferred an appeal under section 100 CPC. Sorry, 96 CPC before the Court of Learned Civil Judge Pokraja, which was registered as TA number 4 of 2007. First of the Learned First Appellate Court formulated the question as to whether there is any illegality or irregularity of the Learned Court below in passing the judgment and decree as the only point of determination. Next paragraph. The issues number 2, 3, 4, and 5, as framed by the Learned Trial Court, was visited. And accordingly, it was in respect of issue number 2, having referred to the evidence of the PW3, it was held that on a scrutiny of the entire evidence, it was found that the appellant had failed to prove the sale and purchase of the suit land and as no title deed was submitted by the appellant for transfer of the immovable property valued at more than ₹100, where registration is compulsory, and on considering that there was no consent of the respondent number 1 for entry of name of the appellant in the Chitta book in respect of sale of the land, it was held that the Learned Trial Court had correctly decided the issues against the appellant. First off, in respect of issue number 3, the Learned First Appellate Court took note of the admission made by the appellant that she never cultivated on the land as she was a government employee. And that she also claimed title over the suit land by purchase and adverse possession as well as a riot, the Learned First Appellate Court, finding the pleadings and evidence to be inconsistent and contradictory, held that there was no illegality and irregularity in the decision of the Learned Trial Court on issue numbers 2 and 3. Resultantly, issue number 4 was also A decision of the trial court on issue number 4 was also affirmed. Stop. In respect of issue number 5. The claim of the appellant as Rahati under the Assam Temporary Settled Area Tenancy Act 1971 was disbelieved, as there was no evidence in respect of the occupation of the land by herself. And it was held that that under the said 1971 Act, a tenant cannot take a subtenant, and on the ground that the Exhibit 2 was not proved by calling witnesses from the Revenue Department, the same was disbelieved, and the decision of the learned trial court on issue number 5 was affirmed. Similarly, in respect of issue number 7, it was held that there was no cause of action for the suit, and resultantly the issue number 6 was also decided against the appellant by holding that the learned trial court did not commit any illegality in the decision on said issue, and accordingly the appeal was dismissed. Next paragraph. The learned counsel for the appellant has submitted that it was an unimpeached evidence of the PW3 that she was in possession of the suit land since 1990 exclusively and peacefully. And accordingly, it is submitted that without the respondents being in possession of the suit land, the decision of the learned courts below was not sustainable, and the concurrent finding of facts was liable to be interfered with. It is also submitted that the exhibit number 2, being the landholding certificate, having been admitted without any objection, could not have been discarded, as the same said document proved. The possession of the appellant accordingly, it was submitted that as the appellant was in possession of the suit land, the general power of attorney executed on 2012-2002 was a void document. Next paragraph. In respect of the substantial question of law, number one, as framed by this court, having perused the pleadings and evidence on record of all the three PWs, it is seen that that exhibit 2 is a copy of a certificate. Is this certificate issued by the Assistant Secretariat Officer, Gosaigaon, Revenue Circle, bearing number GGC within bracket S bracket closed L, R 3/2003/5 dated 7/1/2003, certifying that the name of the appellant and two others were entered into the number 2 Katyan in respect of dock number 47 within bracket old, 79 within bracket new of KB Pata number 1 within bracket old, 1 within bracket new of Patmari. Is it Rajabri? It is Patmari, village Patmari. Village Patmari.
Pathimari.
Pati, PATIMARI. Huh?
Page 8, my lord, page 8, para 2.
Just give the spelling.
Pathimari under revenue.
PATIMARI.
PATHIMAR.
PATHI. Okay, MARI. Under Gosaigaon Circle. First off, in respect of the appellant, it was mentioned that her share was 3 bigha. Her share as Rayat was 3 bigha. Full stop. In this regard, it is observed from the entries made in Exhibit 2 that the said certificate was prepared on the basis of draft chitta as well as entry made in 2 number Khatian. Full stop. The said original records being available. There is no explanation by the PWs, specifically by the appellant within bracket PW3 as to why the original record could not be called for. Full stop. A certificate would always be a secondary evidence in the absence of the proof of the original or the original being proved, the rejection of the said evidence by the learned in concurrent finding by both the courts below cannot be faulted with. Nonetheless, the certificate being obtained from the office of the ESO, Gosaigon Circle, the said certificate is required to be proved by the author of the document. Full stop. As the author of the document was not called for, the rejection of the said evidence by the learned courts below, being concurrent finding of fact, is not found to be perverse, and therefore the said finding is not liable to be interfered with. Full stop. Accordingly, the first substantive question of law is decided in the negative by holding that the Exhibit 2 was not a valid document to prove entries made in the Khatian or in the draft chitta. There is another reason for rejecting the same full stop, which is that a draft chitta is merely a draft and cannot be held to be a primary evidence of the entries made in the revenue records. Full stop. Therefore, a certificate placing a reliance on a draft chitta would be a secondary evidence of an evidence which is itself secondary, i.e. the draft chitta. The name draft chitta itself suggests that it is merely a draft that has not been approved to be a final chitta, which otherwise finds entry in the Jamabandi. First of, therefore, ownership by way of entry in the draft chitta is again inadmissible in view of the provisions of section 17 read with section 49 of the Registration Act. Yeah, gap goes this, so and so. First, next paragraph. From the discussion on the issues number 1 to 7 made by the learned trial court as well as the learned first appellate court, it could not be demonstrated that there was any material irregularity or perversity in appreciation of the pleadings or evidence by both the learned courts below. Full stop. Therefore, comma, the second substantive question of law is also decided in the negative and against the appellant by holding that there was no material irregularity in appreciation of the evidence by both the courts below. Next paragraph. In view of the finding recorded in respect of substantial question of law, number 1, comma, in respect of substantial question of law number 3, the court is inclined to hold that this is not a case where the learned trial court had failed to appreciate the statement of the PWs and the exhibited documents in its true perspective. Full stop. The learned counsel for the petition appellant have placed reliance on section 114 of the Evidence Act. Full stop. There's no doubt that under illustration E of section 114 of the Evidence Act, comma, there is a presumption that judicial and official acts are regularly performed. Full stop. Nonetheless, comma, if the original revenue record is not called for, comma, the exhibit 2 being a secondary evidence, comma, which was discarded by concurrent finding of fact by both the courts below, it cannot be said that the appreciation of the pleadings and evidence was not in accordance with law in its true perspective. Full stop. Therefore, comma, no perversity being shown on appreciation of the pleadings and evidence, comma, the substantial question of law number 3 is also decided in the negative and against the appellant. Stop. Next paragraph. No other substantial question of law arose in course of the hearing. Next paragraph. Resultantly, comma, this appeal fails as the court does not find any ground to interfere with the concurrent finding of facts as recorded by both the learned courts below. Accordingly, the appellate judgment and decree dated. Now, accordingly, this appeal stands dismissed, and the first appellate judgment and decree dated 27/6/2008, passed by the learned civil judge Kokrajhar in TA 4 of 2007, thereby dismissing the appeal and affirming the dismissal of suit on the dismissal of TS number 3 of 2003 by the Court of London Munsif Kokrajhar, by judgment and decree dated 27/2/2007 stands affirmed. Next paragraph. The registrar shall prepare a decree. Next paragraph. In the meanwhile, the records of both the courts will be sent back. Mr. Roysuri, I have not mentioned anything about this, because otherwise I have to give some finding of your position and the as a adverse position. I'm not making any statement here. The parties are left to bear their own cost for this appeal. This old records, lot of dust which has. One minute.
Daily list item 3.
Yes.
It's a transfer petition. Transferring of a SC civil divorce case into the Tinsukia district judge.
Transfer petition, section 24. Matrimonial dispute. Mr. D. Fukan for the petitioner. Transfer from which place to which place? Page one. huh? Page one. So and so. Okay. Notice steps within 2 days. Till the next return date, further proceedings of so and so street. But take steps in course of 2 days. Otherwise, we'll revoke the order. 4 weeks. 4 weeks.
Item 4.
Like this, what it today itself. Item number 4.
You see, what I was expecting from you is not this, not only this, but you see, you civil court rules and not civil court rules and orders. You see, this is what I was expecting that you would submit to the.
I just put it today morning.
No. Legally, you must be more in a more sound, better footing than what you have argued on that day. You see, we have not amended the High Court rules just for nothing. So when there is a requirement that the third party rights are available or not must be examined by a trial court, why not in your case, when you are raising a question of third party rights, you should be heard. We have missed out in the civil court rules and orders, and I'm technical on this aspect. So if it's a civil trial or a criminal trial, I would expect upcoming lawyers like you to be more acquainted with the High Court rules and the civil court rules and orders and criminal court rules and orders. Correct. So that day I did not give you any order. I was expecting this from you.
Right.
It's your. Heard Mr. P. Dekada and counsel for the appellant, sorry, petitioner. Next para. By filing this revision under Article 227 of the Constitution of India, read with Section 151 CPC, the petitioner is assailed. The order dated 4/7/2023 passed by the learned Civil Judge Nagaon in Niji case number 27 of 2002, rejecting the application filed by the petitioner for impleading him in the suit as a co-defendant. Next para. By referring to the sale deed, it is submitted by learned counsel for the petitioner that in the sale deed, his share is limited to 2 kata 10 acres of land. Full stop. The who is the plaintiff, 1 or 2? One. The respondent number 1 had filed a suit for specific performance of contract in respect of 2 acres of land.
But 1 and 2 both.
Huh?
1 and 2 both had a plaintiff.
That's what I'm asking. Respondent was 1 and 2. As plaintiffs had filed a suit for specific performance, claiming right in respect of the entire, how much land is there? 2 acres.
2 acres.
Entire 2 acres. It has been projected that the said 2 acre land includes 2 kata 10 acres of land of the petitioner. Full stop. It is also demonstrated from the impugned order that although the learned trial court took cognizance of the fact that the concerned sale deed refers to a specific share of the petitioner over 2 kata 10 acres of land, yet the third party rights which is accrued in favor of the petitioner was not protected by the impugned order, as the prayer for impleading has been rejected. It is the submission of the counsel for the petitioner that it would be too iniquitous to prevent the petitioner to be joined as co-defendant, and thereafter when a decree is passed against him, he would then get an opportunity of contesting the execution proceedings. Stop. Next para, in view of said submissions, and on considering that in a joint sale deed in favor of the petitioner and the respondent numbers 3 to 7, wherein the specific share of the petitioner is 2 kata 10 acres. Court is inclined to issue notice written within 4 weeks. Requisite extra, whenever the petitioner shall take steps within 2 days for service of notice on the respondents by registered post with AD. In addition, the next para, till the next returnable date, the further proceedings of title suit number 96 of 2020 shall remain pending before the Court of Learned Civil Judge Nagaon. Civil Judge within bracket Senior Division, it was Nagaon, shall remain stayed. Next para, the petitioner shall produce a certified copy of the order before the Learned Trial Court to bring the order to the notice of the said Learned Court. You file this by way of affidavit. I'm not saying anything.
Item
Item 5.
Here one necessary correction is required to be made. Madam, this is page number 5. Okay, revision petition.
Yes.
This page has been similarly inserted in page number 7.
Pardon me?
Page number 5. This page has been similarly inserted in page number 7. The single page has been inserted twice.
Oh, yes.
Therefore, document done sometime. You can say correction.
Okay, okay. Mr. G. Bharadwaj, counsel for the petitioner. Praise for is granted liberty to make necessary correction in this revision petition. As he has submitted that page number 5 and page number 7 are similar, and therefore he has left out the this is to be only taken out.
Taken out.
It's only to be taken out.
Only to be taken.
Rest are same.
Rest is same.
Allow me to strike out page 7. To stop. If prayer is allowed, the learned counsel for the petitioner is permitted to strike out page number 7. So we permit you, you can do it here. Now, what is your submission?
Well, this revision petition we have filed against the order dated 28/6/2023, whereby the prayer of the respondent for interim maintenance of 30,000 was allowed.
You are drawing a pension of 14,000.
14,000. Presently, it's 18,000. Presently, it's 18,591.
15,000,
18,591.
18,591.
91. And I am also paying a maintenance of 3,000 in another proceeding.
Okay. Next paragraph. By this revision, filed under Article 227 of the 115 of the Constitution, 115 CPC, the petitioner is assailed. The order dated 28/6/2023, passed by the learned District Judge Bongaigaon in Misje case number 23 of 2020, in TS within bracket divorce bracket was number 40 of 2020, allowing granting pending delight maintenance of rupees 30,000 to the respondent till disposal of the suit. Next paragraph. It is projected that as per the pension payment order, the petitioner is getting a pension of rupees 14,000 per month, which has now been enhanced to rupees 18,591. And therefore, the order of maintenance exceeded his monthly income. Next, you should notice returnable on so and so. It is also submitted that the petitioner is paying maintenance in a criminal proceeding filed under section 125 CRPC by the respondent in terms of order passed by the learned additional sessions just the fund bench, granting maintenance of rupees 3,000 per month. And this said the liability of the petitioner was also not considered by the learned District Judge Bongaigaon. Next, I should notice a returnable on so 4 weeks. Give a fixed date. If it's from outside, give after 5 weeks. List notice is made returnable on so The petitioner shall take steps for service of notice on the respondent by registered post with AD. Next paragraph. Till the next returnable date, comma, the Indian order dated 28/6/2023 passed by the Honorable District Judge Bongaigaon in BJ case number 23 of 2020 shall remain suspended on condition that the petitioner, apart from paying maintenance in terms of order passed under section 125 CRPC, comma, would also deposit a sum of rupees 2,500 per month before the court of Learned District Judge Bongaigaon in connection with Mijia case number 23 of 2020. Full stop. It is made clear that if the interim maintenance as ordered by the court, this court is not deposited, comma, this interim order of staying the operation of order dated 28/6/2023 shall stand automatically revoked. But within 10 days, within 10th of each month, within 10th day of each month. So this order of 30,000 is being modified to 2,500. But this, if you don't pay, then your that interim order will stand vacated, and it will be open to the Learned District Judge to enforce its order.
Hello.
Date 20 November.
You correct that. You strike out koribo. Page number 7 strike out koribo. Cutting sign koribo. Yes, item 6.
Well, this discussion we have challenged and order out by the executive court. That is page 52. This
Page
page 52.
52. Yes.
This may be question for all of us.
Don't read that just for the illegality.
Whatever this order was passed basically based on the report that is page 50 Lordship. In fact, that report is in my favor, in our favor, Lordship. Because the report has clearly specified that there was a certain quantum of land is less than the actual quantum of the land of the present petitioner. Despite of that, Lordship, the Learned Executive Court observed that there was no objection filed on behalf of this by the judgment after. In fact, Lordship, the judgment after Lordship have no objection regarding the Lordship execution of the decree, Lordship. Our objection was only that the land of the petitioner as well as the path of Lordship regarding the 3 feet of the land that is to be asserted. Accordingly, Lordship, that executive court has already passed an order that is Lordship page 42. That there was a need to ascertain the land of the petitioner. That is schedule A and schedule B. That is clarified in page 43. This 48 is the report.
So how is this order? Imperial order is creating difficulty for you.
The difficulty is there. Matlab the Lordship kindly come to page 51. This is the space map of the Lordship in the anticipation. There
Yes.
is a path lawsuit. We are saying that this path is lawsuit belongs to the land of the petitioner. We have no objection that there may be a path lawsuit on their own land. That is the house of the judgment decree holder. That is,
Where is the decree?
Matlab,
Where is the decree of the first of the trial court?
that is space lawsuit 21 lawsuit. Their counterclaim has been lawsuit decree in their favor. Our suit was dismissed.
No, then don't you think? Are you convinced about this maintainability of this revision? You see, if you dispute that degree, you go for an appeal. This is what you call in the execution proceeding when there is a commission.
Yes,
That report can't be disputed by you.
but this report lawsuit, this report is in supporting the case of the petitioner. Our case is supporting by this lawsuit report because if the lawsuit kindly come to page 49, last paragraph. Further, it is also to be mentioned here. During measurement, it is found that Schedule A land measuring 13 kata 0 sotak and Schedule B land measuring 9 kata 5 sotak 5 gunda, total land measuring 1 biga 2 kata 5 sotak 5 gunda, which is 1 kata 5 sotak 10 gunda less from the above mentioned land. Our total land was 1 biga 3 kata 14 lesser 10 gunda, but technically it was found 1 biga 2 kata 5 sotak 5 gunda.
So you see where your land has gone is not for the executing court to find out. The finding is that east to that Schedule A land is the path, and that is confirmed by the commission report, and therefore the court is executing the decree giving the position of the path. So if you have your claim, you have to agitate it separately. Your suit has been dismissed.
Our contention is there. That path is to be ascertained where it is existing.
No. In execution of the decree by appointing an commission, that has been done.
So, but the commission report is saying that my land is lesser.
No,
than-
your land is lost, but where it is lost, it doesn't say. That commission report doesn't say that the path is your land. And your suit has been dismissed. So, what you call in execution proceeding, also there's it's permissible to have an commission. Therefore, nobody objected. And when the finding of fact is there, you see, in order to challenge that report, what will you have to do? You have to cross-examine this persons who have done the commission. That was not done. And their land is lost. Where it is lost, we don't know.
My submission is we will not go to challenge this report.
No.
Because report.
No, I'll tell you. You see, you had some plot of land. From wherever you trace that land, so let's say Jamabandi or your sale deed or whatever, you had a particular plot of land, and now your land is lost. But the decree is for that path. So you can't, you see, when the counterclaim is decreed for that path, now you can't say that my land is lost and therefore this path is my land. It is not for the executing court to decide that. You have to challenge that decree on the ground, but that has not been challenged. This can't be maintainable. It's a collateral attack on the decree.
There is a particular path.
No, but
Now
you see
that
that
part has
you are
been
challenging.
lawsuit. They are trying to prevent that path.
No, that is something which the suit will decide. Your appeal will decide. Executing will not decide that from where that path has come. It is not for executing court to decide. The suit has been dismissed and the counterclaim has been upheld for that path of land. The commission report says that there is a path. So in revision, we are not upsetting the decree. Our collateral challenge to a decree will not be maintainable in a revision. You don't file an appeal, but you challenge the decree collaterally.
Opportunity they have to.
You have your avenue open wherever you want. But this is a dead end road. This revision is a dead end road. You may have an avenue anywhere.
Our contention was only that their
You know, there's a
part
distinction
maybe-
between, there's a distinction between avenue and a road. No, but that's a collateral challenge. We'll keep it open. You want to go there, you challenge it, make an observation. As on what you call in this regard, based on your submission. Heard Mr. M. Khan and counsel for the petitioners. to start. By filing this revision under Article 227 of the Constitution of India, the petitioner has, the petitioners have assumed the order dated 11/9/2023, passed by the honored civil judge within bracket senior division, bracket close, Hailakandi. In connection with title execution case number 11 of 2019, thereby allowing the respondents, degree holder, to continue with their construction work of boundary wall in accordance with the decree and survey report. Next paragraph. The petitioners for the plaintiffs in TS number 12 of 2016 wherein the respondent number 1 is the principal defendant and the respondent numbers 2 and 3 are the pro forma defendants. The player in the plaint was to declare the petitioners as the legal owners of the suit land described in schedule to the plaint. For recovery of half position over the dispossessed 2 kathas of land. The respondent number 1. WS was filed by respondent number 1, not the defendant number 2 and 3 did not join. Defendant number 1 filed a written statement and contested the claim of the petitioners and also filed a counterclaim. To stop. The copy of the written statement as well as counterclaim is not annexed to this revision petition. To stop. However, comma, it appears from the discussion on additional issue number 3 capital A in the judgment and decree dated 26/11/2018 passed by the Learned Child Court in TS 12/2016 that the respondent number 1, as counterclaimant had prayed for a decree in respect of 2 katha land of second RS Patta number 1, RS Patta number 1725, Tag number 1981. And while deciding this additional issue number 3, capital A, the learned trial court found the respondent number 1 within bracket counterclaimant entitled to cast position of only the 3 th 3 with bracket 3 qubit CUBIT path from the petitioners and no other, and accordingly the counterclaim to the said extent was allowed by directing that the cast position of the said path be restored to the respondent number 1. Full stop. In connection with the execution proceedings, being title execution case number 11 of 2019, the learned executing court by an order dated 21/9/2022 was of the opinion that the that a proper survey was necessary for ascertainment of the path by measuring both Schedule A and Schedule B land. And it was also observed that there was no necessity to conduct a separate survey because position would be delivered only on proper measurement of the aid of the Amen Commissioner. First off, in this revision petition, it is also posited that the respondent number 1 started construction of the of a Pakka wall in respect of a footpath, and therefore by order dated 26/4/2023, the respondent number 1 was restrained from continuing construction of a Pakka wall till disposal of the execution petition. The assistant settlement the assistant settlement officer, Hailakandi Revenue Circle, forwarded the report dated 14/7/2023 to the learned executing court. Amongst others, reporting that there was a 4.5 feet road available in the land described therein from the capital MB road on northern side of the eastern boundary of Dag number 1981 to the south side up to southern boundary of Dag number 1982. And that the said 4.5 feet road was connected with the southern side of Schedule A, TO2, MB road, M capital B capital road, via south-east side of Schedule B, land full stop. The sketch map was enclosed with the said report. Full stop. The measurement of Schedule A and B land was also contained in the said report. Full stop. Next paragraph. Accordingly, the Learned Executing Code, order dated 11/9/2003, recorded that there was no objection to the said survey report, and there being a 4.5 feet path in existence, the prayer of the decree holder were allowed, and they were permitted to continue their construction work over the boundary wall in accordance with the decree and survey report. Full stop. Next paragraph. Agree with the said order, the Learned Counsel of the petitioner has submitted that as per the said report, dated 14 July 2023, the said report was favorable to the petitioner, as it was mentioned therein that the Schedule A land, you are concerned with A or B? B, that the Schedule B land covered by second RS Pata number 175 or DAG number 1981 within bracket P, land measuring 9 kathak, 5 chatak CHATAK. You copy it from page 50. Blue pencil. As the petitioner, as the Learned Counsel for the petitioner submits that the petitioners are only interested in Schedule B land, description of Schedule A land is not referred in this order. Full stop. It is submitted that as per the said report, there is a shortfall in the landholding of the petitioners, and therefore the suit path, which has been decreed in favor of the respondent number 1, was an integral part of the land of the petitioners. So accordingly, it is submitted that the executive court have committed a gross error in executing, in allowing the respondent to take over possession of the 4.5 feet path and to encircle it by raising a wall. Next paragraph. In this connection, the court is of the considered opinion that that as already indicated above, in the suit the petitioners had claimed right at an interest in respect of the suit line described in the schedule of the plaint. It includes two katas of land from which the applicants have been, the petitioners claim to have been dispossessed and is yet to be recovered, which is mentioned in Schedule B for the plaint, correct? Full stop. The claim of the petitioner was rejected and the suit was dismissed, and the counterclaim of the respondent was allowed to the extent of 3 cubic path to the existence of Schedule A land and to the adjacent of west of the Schedule B land, which was ordered to be restored to possession of the respondents. Therefore, if the Amin Commission report, which is forwarded in form of a report dated 14/7/2023 by the Assistant Settlement Officer, is otherwise not objected to, the impugn order passed by the Learned Trial Court is not found to suffer with perversity requiring interference of this court. Full stop. Next, at this stage, the learned counsel for the appellant has submitted that insofar as the decree is concerned, the appellants would have a right to challenge the same. The same is not disputed, and if the petitioners feel aggrieved by the decree that has been passed, again, it will be open to them to make a challenge, if so advised and if and subject to law of limitation. Next paragraph. There's one more reason not to interfere with the impugn order, which is the fact that in the impugn order dated 11/9/2023, it has been mentioned that the petitioners as judgment debtors had not come forward with any objection against the survey report, and that there is a 4.5 feet path in existence. Therefore, once a report of the commissioner is not objected to, it would not be in the interest of justice to interfere with the impugn order based on the report of the commissioner, which is purportedly in excess of power under Order 21, which is that power commission report Back कर दीजिए, दूसरे आंसर। After this, that will come. And at this stage, he submits. That will be after that. So next para, accordingly, this revision stands closed without interference with the order, with the order impugned, with the order dated 11/9/2023 impugned this revision, which is passed by the learned civil judge, senior division, Hailakandi. Okay, Mr. Khan, that was that. According to the submission, continue post lunch. pendant maintenance. Full stop. In that view, the matter, comma, the court is inclined to direct both sides to appear in person before the learned trial court at Dibrugarh, and by and on production of a certified copy of this order, comma, the learned district judge, this is your district judge. Additional district judge Dibrugarh shall send the parties for mediation so as to through a trained mediator, so that the dispute of the parties can be mutually settled in mediation. Next, listing the motion again on 12/10/2023. That's a downloaded copy. Okay, downloaded copy. इसमें ऐड कर दीजिए. If it is made clear that the parties agree for a negotiated settlement, comma, it would be open to the mediator to extend the mediation proceedings, not exceeding 30 days from 11/10/2023. Okay, then will be list on so and so.
Item 10.
Yes.
We have taken a specific stand that there are other properties other than the food like which to be so the specific stand in the WS. Then when that is proceeded and when it is principal also period, we find it
No, but you have taken a lot of adjournment. I'm not inclined to grant you any further opportunity. Yes, because cost was ordered 25 to 23. You did not submit the cost. The records show that the suit is pending for cross-examination since 21/5/2022. DWs since 21/5/2022. This is more than 1.5 years. Yes. 51. Yes. Official witness. No, it's not a question of that. We can excuse language, but the question is that whether he is cited as a witness when the issues were, no, then we can't allow that. No, you see, when you are calling a witness at your own cost, then you don't require the specific order of the court. That if the court permits, you can. Yes.
So this petition is in my humble submission,
Where is the order? Oh, how does the trial court deal with it? So court has invoked order 16 rule 1(3). No. For that you can't have a petition. It is just like filing an adjournment petition saying that today is a date fixing the, for fixing another date in the case. You understand? Today is the date fixed in the suit for fixing another date. It's not that because this is a petition I've dealt with. Petition is filed that today is the date fixed in the suit for fixing another date. And therefore another date should be fixed. No, whatever we, but the fact is that if you can bring it, we can, because that the court has a discretion.
Once the court has invoked and court has rightly said that we have not mentioned any sufficient cause why this court has not cleared. Why there is no sufficient cause in this petition, the omission of the name.
Just so from your pleadings or anywhere that what this official witness will do.
From the WSA,
15. This is suit for partition.
Here we have taken a specific stand that the plaintiff has other properties in West Bengal and in some other areas. Official witness was sought to be called to prove that there are other lands in West Bengal. The possession of the plaintiff. Those are not the subject matter of this.
Page 13, which paragraph?
There are factors of what there is a subject. Many paragraphs where we have referred to this relation. Second paragraph. They have stated that Blackstone has another partition of the left then that they have taken the other properties. We have been left with this property.
That also doesn't appear to be a cogent reason. We come to page 44 onwards. This is your document. Defendant document. None of the defendant documents is the name of this Makhan Chandra Pal or Nihar Pal. Page. Uh, 46 and 48 are same. No, you see page 39. Second line now, after the third line, after the plaintiffs stating falsely instituted, it is mentioned that after Shraddha ceremony of so and so, then talk of partition of left properties was raised in the privacy under the confirmed right to so and so. The properties at Coosbihar, West Bengal in England, lying in the name of Makhan Chandra Pal, so and so, agreed to be partitioned. So it is only that land of your father which was to be partitioned. Now, where is the statement that the land in the name of plaintiff was also required to be put into the common hodgepodge and then partitioned? That is not your case. 13. No, I don't find anything. Read the other part. No, forget these people. I am only on that. You see, what will divide is your father's property. Oh, okay, Suniti Paul. Okay. So this, no, you come to page 46 and 48. These are not the property of your mother or father, but this is the name of Nihar Pal. He is the plaintiff. You see, in the readings, you must have a foundational facts that the land of the father was illegally mutated and therefore you want it back in the common house and then again partitioned. That is not your prayer. Your counterclaim is not there. So therefore, you see, without a counterclaim, even if there is a suit for partition, if you don't introduce those facts, your property of the plaintiff can't be partitioned. And if you are asking your what you call the land revenue staff from West Bengal to come here and prove that, it will prove nothing.
They have taken some portion of the assessment property. They have left this property to be enjoyed by this brother.
No, you see, that's okay. But once you have agreed to it, where is the question of again bringing a land revenue staff and proving it? I'm trying to understand your case. You will need certain the official witness for certain purpose.
Because they have suppressed those facts that they are in the position of any other rights. That is nowhere in their.
So very the simple question I'm asking, it's a what you call, I am not traveling on a straight line. What you call, yesterday also I used the term. It's a question in the jalebi form. So one question leads to another, another leads to the third one. You see, why I'm saying about foundational facts is that without a foundational fact, how will you bring a witness and prove what? It is only the pleaded case you can prove. And in the pleaded case, it is not your case that the plaintiff has usurped your father's and mother's property, transferred, got it mutated in his own name illegally. That's not your case. So what will the person come and prove? 41. Yes.
Defendants are waiting for payment of the state defendants and plaintiff are delaying. It is further submitted that though the prayer for injunction of plaintiff and his associates trying for illegal gain, there is no chance of suffering any injury or loss if the injunction is.
So that means your whatever evidence you want is against your co-defendant. No, but that is, you see, although it's a suit for partition, everyone has a share, everybody has a right. In a partition suit is a suit where everybody is a plaintiff, everybody is a defendant. Correct. But where is your statement against the plaintiff here?
The defendants are waiting for payment, but the state Tokoma defendant and the plaintiff are delaying.
So you're essentially what you are asking against is your co-defendant, but there is no counterclaim.
Because those properties are not within the jurisdiction of this.
No, in a partition suit, that's not required. You don't have to file 10 partition suits if you have property in 10 cities. Partition suit permits non-jurisdictional court to entertain the partition.
This petition, as it is partition suit, ultimately it's the fact finding that has to be made. I have stated that they are in possession of any other property which they have not mentioned in their claim. And I have just pointed
No, just tell me a situation. You see, let us say A is envious of B. My examples are always horrible, huh? Maybe inappropriate, but just an example. Now, A is envious of B. He files a suit for whatever purpose. He files a suit, and in the suit he says that I'll call a Latpandal from the Guwahati Revenue Circle to prove that he has got several properties. You see, disproportionate. Basically, he is attacking that he is a incorrect man and there is a disproportionate property. So he files an application that I will prove that he has got disproportionate assets and therefore he is an illegal person, wrong person. Now, please tell me, without the introductory facts, can the Latpandal or the circle officer from the Guwahati Revenue Circle come and then start saying that excess property at A, B, C, D, E, F, G, H? Is that permissible? Roving and fishing inquiry by calling a government official, can that be permissible? I'm asking you because there is no counterclaim. Foundational facts that this is an asset of the father, that's not there. No, Mr. Mukherjee, this is will not permit that. No, not last time. Last time you give me an order, I returned it back.
When the petition, as I pointed out, taking time for producing not clear as to what provision subsection 3 or
No, there are judgments of this court as well as Supreme Court of India that non-mentioning or wrong mentioning of a provision of law will not vitiate the petition itself. So you'll have to be sure whether you have filed an application for adjournment or it's a prayer for asking an official witness to come.
prayer for asking the official witness to come, there is to be a specific.
So that was not made. So perhaps perhaps the plaintiff is not in good hands. No, you see, we can't condone the inefficiency of a lawyer in the trial court. It can't be a substitute to that. Because if a lawyer is filing a petition, which is signed by the party, it is for the for you to tell us what the petition is about. Why should we find out whether it's an adjournment petition or it's a prayer for calling for the witness? Why should we exercise that? No. Once the opportunity is closed, you can't reopen it. It can't be that can't be permitted. It will be more illegal than the initial order itself. No, Mr. Iqbal's smile shows that he is objecting. Okay.
Going by the procedure is the embed of this. section 30 of the CPC, when you want to go to find out the court, it says the court on its own motion can also call for any document.
No, correct.
Finding that
No, that is the decision on the court. But that is for the court to decide which document is required to be called.
because the petition I filed was basically for an adjournment.
No, you see, that's only an extension of what is there in section 165 of the Evidence Act. Section 165 of the Evidence Act said the court may put some such questions to the parties or to produce such document as it may deem necessary, and the other side will have no right to object. That is 165. And therefore, the section 30 is only a enabling provision. Evidence Act is 1872. CPC is 1908. So it's merely adopting that, nothing more. Mr. B.J. Mukherjee, London Counsel for the petitioner, and Mr. A. Iqbal, I'm sorry. A. Iqbal, London Counsel for the respondents. Next one. By filing this application under Article 227 of the Constitution of India, read with Section 151 CPC, the petitioner has assailed the order dated 17/7/2023, passed by the London Municipal Number 1, Kokrajhar, in TS number 10 of 2021. Full stop. By the said order, the learned court had rejected petition filed by the petitioners defendants to summon official witness, and also rejected the prayer to deposit area cost and to proceed with the examination of DW 2 and 3. Next paragraph. The petitioners are the defendants in TS number 10 of 2021, which was filed by the respondent as plaintiff. Full stop. The suit was for partition of the suit property described in Schedule A and B of the plaint, for recovery of class position and consequential reliefs. Full stop. The petitioners, as defendants, had contested the suit. Full stop. In course of trial, the witnesses of the plaintiffs, by plaintiffs apostrophe S, side were examined and cross-examined and discharged. Full stop. From the records, it appears that the case is pending for DWs since when? 21? 5/2020. 22. Where is this petition number 219? Where is that? Nine. Then what is this prayer? Page 49, your prayer is 2120. You're saying 22. So why recalling of order of 2020? What is that? 22. 23. Okay. Okay. Next para. Where is that order of costs? In your petition at page 49, you said it cost, but what is the order of cost? Okay, it would be sufficient to mention that as per the contents of petition number 219 of 2023 within bracket annexure 4, comma, the case was fixed on 19/12/2022. No, sorry, on 21/2/2023 for cross-examination of DW1. Full stop. On 19/12/2022, comma, the evidence on affidavit of DW2 and DW3 were furnished. Full stop. However, by order dated 25/1/2023, the learned trial court was had discarded the evidence of DW2 and 3 due to non-payment of cost. Full stop. By the said petition, it was projected that the DW2 and 3 were not aware. Oh, sorry, the defendant number 1 was not aware of imposition of cost as a condition for cross-examination of DW2 and for acceptance of evidence on affidavit of DW2 and 3. And accordingly, a prayer was made to review the order dated 20 January 2023 and allow cross-examination of DW2 and 3. Full stop. Another petition number 218 of 2020, 218 dated 21/2/2023 was also filed to allow the defendant number 1 to issue notice to the official witness of Kuch Bihar and depose in this suit. Full stop. Both the petitions were rejected by the impugn order. Next paragraph. The learned counsel for the petitioner submitted that for the petitioners has submitted that the petitioner number 1 was not aware of the imposition of cost and therefore the cost was not paid. Full stop. The said submission. Is found to be devoid of any merit. Because it is the contention of the petitioner in paragraph 4 of this application. That's the case was fixed for DWs since 21/5/2023. Full stop. The number of adjournments taken by the petitioners has not been disclosed in this application. Full stop. Nonetheless, it appears that more than 3 adjournments as available. Where? (52) 6. No, you see, after 21/5, what is the next date? After no, you see, the sequence wise date is not there in the order. Sequence wise date is not there because today I can't say what is the date fixed. So nonetheless, the more than permissible adjournments under Order 17 Rule 1 has been availed by the petitioners. First off, at this stage, the learned counsel for the respondent has produced a printout of the case status in respect of the said suit. Which shows that the case was fixed, the suit was fixed on 21/5/2020, 21/5/2022, 26/2022, 13/7/2022, 10/8/2022, 8/9/2022, 31/10/2022, 21/11/2022, 19/12/2022, and 25/1/2023 for evidence on affidavit. And the cross-examination of DW1 was fixed on 21/2/2023. Thereafter, it appears that the suit was pending for hearing on petition on 27/3/2023, 2/5/2023, 24/5/2023, 22/6/2023, and thereafter the order was passed by the Learned Trial Court on 17/7/2023. Full stop. It appears from the impian order that the cost imposed by the Learned Trial Court was not paid on 31/10/2022, 21/11/2022. First stop. On 19/12/2022, when the evidence of DW2 and 3 was submitted, the cost of rupees 1,000 was not deposited And the learned trial court had ordered that the said DWs would be accepted only on payment of cost. Full stop. However, when the matter was fixed on 25/1/2023, the cost was again not paid. Full stop. Therefore, when the learned trial court had accepted the evidence on condition of deposit of cost, the non-deposit of cost, for whatever reasons, was sufficient for the learned trial court to pass the order dated 20 January 2020, 23, 20 January 23. No, 20 January 2022. 23. No, it can't be 23. Because as per this note, there is no date on 20 January 2023. There is no 25. Your page 50 is not 25. (21 to 2022) is the date as per your document, this one. But that day it was for PWs. No, they just say, don't say the GIT date. Or closing the (25/1/2023). The evidence of DW2 and 3 was discarded. So you may mention that the respondent number 1, sorry, with the petitioner number 1, paid cost of rupees 1,000 in court, but the same was for cost of it, cost against her cross examination, and it was not a cost which was imposed as a precondition for acceptance the evidence of DW2 and 3. Full stop. Next paragraph. Moreover, in the petition number 218 dated 21/2/2023, in respect of petition number 7, it was submitted that the said petition was could not have been construed to be an application under order 16 rule 1(3) CPC, as it did not mention the name of the witnesses, and it was merely appeared for the learned trial court to allow the applicant, petitioner number 1, to issue notice on the official witness Full stop. In this regard, it is seen that in the imbued order, the said petition number 219, so 218 dated 21/2/2023 was construed by the learned trial court to be an application under order 16, rule 1 within bracket 3 CPC. And accordingly, as the name of the said witness did not appear in the list of witnesses, the learned trial court did not find any reason to allow the petition number 218 of 2023. Full stop. Next, in this regard, court is of the considered opinion that without insistence on a summons to be issued by the court, it was otherwise open to the petitioners to call for such to summons such witness at their own cost. So, but as the name of such witness was not entered in the list of witnesses filed before the learned trial court, the court does not find any infirmity in rejecting the said prayer. Full stop. They are otherwise without the assistance of the court. If the witnesses are called, if the witnesses are summoned without the assistance of the court, that would be under the provisions of Rule 1 capital A of Order 16. So in that event, it was not necessary for the petitioners to crave leave of the court to summon such witnesses. Full stop. Next, it may be pertinent to mention that the learned counsel for the petitioner had made certain certain submissions. Stop. Relating to the nature of pleadings, the same is not referred to in this order as any observation made by the court in respect of the pleadings of the petitioners would have the tendency to affect the trial on merit. So therefore, the court refrains from making any observations as regards the evidence vis-a-vis summons to official witness to be examined. It would suffice to mention that as the official witness from the land records of the government of West Bengal is not a listed witness, the court does not find any legal infirmity in the order passed by the learned trial court. Next paragraph. The learned counsel for the petitioners has also submitted that in the event the evidence of DW 2 and 3 is discarded, the respondents, the petitioners would suffer a serious prejudice in the trial. In this regard, the court is of the considered opinion that merely because the petitioners would suffer prejudice in the trial is not a sufficient ground for the court to invoke jurisdiction on Article 226 of the Constitution of India and to interfere with an order in respect of which no jurisdictional illegality or perversity is found. Most of the power of the court is not available to do complete justice under Article 226 of the Constitution of 227 of the Constitution of India. Full stop. Next word, therefore, comma. Having not found any infirmity with the legal infirmity or perversity in the order of the learned trial court, comma, the no case is made out in this application for interference with the the order dated 17/7/2023 passed by the learned Mosif number 1 Kokrajhar. So accordingly, this revision petition stands dismissed at the motion stage without issuance or notice on the respondents. Oh, achha, you give the citation. But just before that, you write, in support of his submissions, the learned counsel for the petitioner has placed reliance on the case of capital STG Associates and others versus Tilak Cosmetics and others, comma, within bracket 2018, bracket with 3 GLR 629. Full stop. The sorry, as per the said, as per the said decision, comma, this court had not interfered with the impugn with the order impugned therein. First of how liberty was granted to the plaintiff in the said case to file petition for permitting him to tender evidence of a person named therein as PW4. In this regard, comma, as already indicated above, comma, it is open to the petitioner to invoke Rule 1 capital A of Order 16 to bring a witness. First of how to enable the petitioner to do so, comma, no order from this court is required. First of accordingly, if such an application is filed, comma, the same would be examined by the learned trial court in its own merit without being influenced by this order. First of resulting, this application stands dismissed without any order as to cost. Keep it discharged, Mr. Iqbal, for the keep it stands discharged.
DBS. DB is an EP server.
Yes, item 11. Yes. No, you see, the trial court is right. When once a notice is issued in an execution case, notwithstanding that 2 years have not elapsed, but the court can't, what you call, turn around and say that now notice is not required. So the only alternative is you withdraw this petition, you move the trial court to have a newspaper publication, do it in one newspaper and end of the matter. No, you should have told that the court earlier, but the trial court, the executing court, notwithstanding that provision, issued a summons, issued a notice. No, I understand, but you can't do anything now. You see, in a suit, that branch manager was not there, but notice was issued to him. Trial proceeded. Now execution case is there. In execution also, notwithstanding the provisions of notice not being required to be sent within 2 years, the court issued a first order to issue notice. At that time, you did not object. Now you see, when in the pendency of a proceeding, I can't give an order not to issue summons. You're reading which paragraph? 6. Yes, please continue. Continue, please continue. I'm hearing you. This guy doesn't help you. You see, this doesn't help you. The reason being, in this case, what had happened, there were 3 orders passed by the Rennet executing court to issue process in the execution case without notice. So that was challenged before the court, saying that the issuance of process was wrong and therefore it should be set aside. And in that connection, the then Shillong bench of this court held that there was no requirement of issuing a notice. You see, this judgment, how will it help you? In this case, what has happened was the executing court had issued a notice. No, if it is not there, you can always file an application, because you see, now you see the power which is available with the executing court is not available with this High Court under 227. Are you thinking that I will pass an order in 227 without issuance of notice on the respondents? Is it permissible? That is the first question I am putting to you. Whether the party exists or not exists, or whether the execution is within 2 years or not, whether this High Court in 227 has the power to exempt issuance of notice and then proceed with the matter. So that's why I said it would be best in your interest to withdraw this petition, file an application before the trial court, executing court, to issue notice by substituted service. That will be easier on your part. But if you, because the High Court does not have power to exempt, this is not an extension of execution. So that I would proceed in the matter on the basis of order, what you call 21 rule 22. So that power we don't have. I think it would be in your best interest to withdraw this. You seek a liberty to take a newspaper notification. You can do it in any newspaper you want. Correct. Mr. M.A. Islam, counsel for the petitioner, seeks to withdraw this petition and to move the learned executing court for service of notice on the respondent number 2 in a substituted manner by publishing it in the newspaper, in a newspaper, on the ground that the office of the respondent number 2 being closed, is deemed to be avoiding service. If there is allowed, the matter stands dismissed on withdrawal with liberty as prayed for. I'll take this back.
Item 12.
Yes. What is your prayer here? Where is that? Where is your petition first? State vacating application was dismissed. We can only issue notice at this stage then, in this application. It's okay. We are only issuing a notice because we can't do anything. At this stage, we can't do anything. No, facts are not required. You see, by interim order, I can't do anything more. Once a case is dismissed. Huh? We also hope that.
Yes, Your Worship, we have received, Your Worship. We have received the copy. Your Worship, there are certain pertinent points before Lordship may issue notice. If I can see.
No, then I'll hear it. If you want hearing, after half an hour, we'll take up hearing, entire hearing. We'll take it up today.
Otherwise, your Lordship may issue notice that I.
No, then we'll hear it at 4 o'clock. We'll start hearing you. We'll hear you and dispose it off.
Thank you, Lordship.
At 4 o'clock, let me finish some matters in the half an hour. Because if I am to hear on the facts at this stage,
Because
I
Your
might as-
Lordship, I was not, my only limited issue that I wanted to raise was with respect to the maintainability of this instant petition that has been filed at this stage. It is only with respect that, and not on the merits of the petition.
okay,
as such.
how do you question the maintainability?
Your Lordship, actually, time and again, the Supreme Court has reiterated the minimal scope of interference of the courts in arbitration matter. This is an arbitration case. This has arisen out of an arbitration dispute. So, Your Lordship, what happened is that we have filed a Section 34 petition challenging an arbitral award. The correctness of an arbitral award and also an additional award. We have challenged both. And then we filed this application in October 2020 before the allotted district judge here, the additional district. Section.
What is that petition?
The petition is the Section 34 petition to set aside the arbitral, basically, to set aside the arbitral. And we also, because nowadays there is no automatic stay, so under Section 36, Clause 2 of the Arbitration and Conciliation Act, we also moved an application seeking stay of the arbitral award according to this act. So the stay was granted in our favor. So the Arbitration Act.
So he filed an application for vacating it. Palm developers. Palm developers.
So Your Lordship, actually, there is no provision given in this act.
Oh, there is a judgment of the Supreme Court in Palm developers that once arbitration setting aside application is filed, then you will have to make a pre-deposit within the meaning of Section 36.
So, Your Lordship, this is slightly different. So it is.
No. You take your own call. If I'm not issuing notice, then I'll hear on merit. Well, it's your choice now.
In that case, if Your Lordship may issue notice, we will file our reply. Issue notice.
We are not only Palm developers, but there is another application with regard to this there are two provisions, power of appeal and power under Section 34. Supreme Court in Section 34 has also interpreted that power under 36 is correlatable to power under 37, and therefore pre-deposit is required to be made.
Your Lordship, actually, this is not.
No, it's okay. No. You see, now I've recollected. That's why I told. Now you are at liberty. You want to issue notice or you want us to hear the matter? I am ready for both.
Your Lordship may issue notice. Oblige, Your Lordship.
Heard.
Your Lordship, we have to file a Wakalatnama also.
Your caveat, that is not required. Your Wakalatnama will be there in caveat. Heard Mr. J. Roy Dunnett, Senior Counsel, assisted by Mr. N. Decker, Learned Counsel for the petitioner, as well as Ms. P. Barwa, Learned Counsel for the respondent. Next matter. Agreed by the order dated 10/8/2023, passed by the Learned District Judge in Miss Arbitration Case number 34 of 2020. The present revision has been filed under Article 227 of the, this application has been filed under Article 227 of the Constitution of India. Next matter, issue notice, returnable. It goes after vacation. Give a date after vacation. Come to so and so.
18 because that date we were already, the matter we had already listed.
10th of 10th of now. Okay. 10, 11, 2023. You've given, you've got copies?
They have filed up, we have received.
Okay. Copy of this application has already been served on the council for the respondent caveator. Next list on.
No, Your Lordship, actually the council assisting me in this matter who is actually the arguing council. So it would be better if we can have it on the 14th instead, 13 or the 14th November, because 10th he will not be able to come down. He comes from
13th you get a walkover. It's a holiday.
14th then. Your Lordship.
14th.
14 is
No,
okay.
14th here matters fixed. Then 15th.
15 is okay.
15. Objection, if any, we filed within that date. 2 days prior to that date. Okay.
Much obliged.
Supplementary list item 51.
Okay, I'll issue a notice. Mr. K. Singha, counsel for the petitioner. Next para. Agreed by the order dated 20/10/2022, page 74. Page 74. 2022. Sorry, order dated 17/3/2022. And 20/10/2022 passed by the learned civil judge Dharan in TS number 10 of 2015, the present application is in filed under Article 227 of the Constitution of India. By the order dated 17/3/2022, the evidence of PWs were expunged. And by order dated 20/10/2022, the petition for recalling of the order dated 17/3/2022 was rejected. Issue notice returnable in 4 weeks. Requisite extract. No, sorry, the petitioner shall take steps. Petitioners shall take steps within 2 days for service of notice on the respondents and perform respondents by registered post with AD. Next para. The learned counsel to the petitioner has prayed for stay of the trial court proceedings. Full stop. It appears from the documents appended in the record that the plaintiff had suffered a fall on 8/11/2021 and suffered cerebrovascular accident within bracket, commonly called stroke, bracket closed, and was also diagnosed of just right VCPI. I'll give you the full name. Within bracket, commonly called paralysis, bracket close. the a coronary angioplasty, CORONARY, angioplasty, ANGIOPLASTY, was done on the plaintiff on 4/1/2023, and he was diagnosed of dilated DIA-LATED cardiomyopathy, CARDIOMYOPATHY. Full stop. He also suffered from lower respiratory tract infection with sepsis, SEP-SIS, within bracket, acute bronchial pneumonia, PNEUMONIA, bracket closed. Full stop. Thereafter, he died. What is the date of death? On 13/4/2023. Full stop. Therefore, it appears that the plaintiff had reasons for not being able to his cross-examination. Accordingly, the further proceedings of TS number 10 of 2015 pending before the Court of Dunnet, Civil Judge within bracket Senior Division bracket close Darang shall remain still till further orders.
Item 13.
Me too. Yes, item 13. Any additional document was filed? No. Last time it took time to file additional document. Has it been filed? Huh? Okay, what is the impugn order? Oh, achha, the petitioner made a prayer in the morning to withdraw his. He made a prayer, but you were not there. I did not pass orders in your absence. We permit him to withdraw it. No, since morning he made the prayer. I excused him from being there. It's okay, but no, whatever be, but at 10:30 in the morning he wanted to withdraw it, but you are not there, so I refused. I'm not imposing cost. Both had Mr. A.N. Ahmed, counsel for the petitioner, as well as Mr. T. Islam, counsel for the respondents, Naspera. The learned counsel for the petitioner seeks to withdraw this petition. So the prayer is allowed despite objection made by the learned counsel for the respondent on the ground that this is the second application which was filed by suppression of material facts, for which he prays for cost. Whether as the prayer for withdrawal is made, the prayer is allowed, matters are dismissed on withdrawal.
Item 14.
Yes. You are the plaintiff or the defendant? You are the plaintiff. Plaintiff tenant. Okay. Your prayer is for the changing of the CI sheet. Where is that? Where is the material to show that there was a theft? Where is that? It's 60. Yeah, just a moment. Yes, Mr. Dega, why we should not permit him to? Urban Area Rent Control Act. Urban Areas Rent Control Act. Section 8, appeal. So this is order under within the meaning of section 7(2).
Section 7, your lordship is aware under subsection 1, notice has to go. Under subsection 2, sufficient cause is not shown.
But why delay the matter? Ultimately, the shop is broken.
That is not the case. In fact, if your lordship examines my plea, what they've done is, under the garb of repair, they vacated the premises, they're virtually carrying out a reconstruction. They've placed before the court all relevant videos and photographs. Wherefore, it is apparent that it's not a repair protocol. They in fact pull down the roof, structural changes are being made, which is why, in fact, there was an earlier round to this. They were carrying on the construction. Thereafter, they moved the court for an injunction to restrain me from preventing them to carry on the construction. That order was passed, my lord, and against that there was a first appeal. In that appeal, the court opined that under section 7, you have to first approach the court. You cannot really undertake construction on your own and then seek an injunction. Thereafter,
So it is a very contesting matter. Then in view of the appeal, we'll have to. Page. Okay. No, but you see, this 8 says any order. Any order may be positive, may be negative. Four, five, 7, 2. Then it's under which provision? No, no, but it's an order under 7.2. Rejection is also an order under 7.2. It can't be without any provision of law. But that's not acceptable. This will not be acceptable. But then would be, you see, you file an application under a relevant provision. No, whatever be, don't take this suit. You take up any other provision of law. The case is filed under that provision. There is a provision for appeal by saying that any order passed therein will be subject to appeal. And then the case, court is rejecting it. And, any order pass, because then I'll have to say that henceforth, under order 39 rule 1 and 2, the court issuing an order of issuing a notice without granting an injunction. Number 2, refusal of injunction. No appeal will lie because order 39, order 43 rule 1 R says any order. No, so no, you see, but that has been interpreted. So what is being interpreted is any order. Sections are not being interpreted. It is the no, but then you see why this power would be given to a landlord or a tenant, agreed by the order. So you see, every application for repair is by a tenant. Landlord will not come to court and say that, no, I want to repair the house of the tenant. Then why tenant? How a tenant will be aggrieved? If the court allows the repair, tenant will say that I am aggrieved. I don't want repair. You file an application for repair, and when the court allows you to repair, then you come to court and say that no, I am aggrieved by the order of repair. No, I'm not asking a question. I'm just thinking aloud. Why would then the the power to tenant to file an appeal will come? You have come in division, not in appeal. It's not under section 8. But I am asking in section 8, why a tenant is given the right to appeal? A landlord or a tenant agreed by any order. So I'm just thinking aloud. Tenant files an application for repair and it is rejected. Correct. Then the tenant can file an appeal. In your case, what has happened? It is rejected. So you have come here under revision, not in appeal. That's what I am reading section 8. I am only reading section 8. I am just. Correct. So that means the only alternative is that a tenant will move the court for repair. And then if repair is allowed, then he will come in appeal. Why, you see, legislature of the state Assam Legislative Assembly, we can't question their wisdom. No, you see, it is adding 7(2). We will have to presume that the wisdom of the legislature is there. It's a presumption, it's there in the judicial orders of the court, that they have got the wisdom. Now they have used 7(2) in this. So I'm just thinking aloud, what would be the option? Why would a tenant come in appeal? It can only happen when his petition is allowed, he'll come in appeal. Is there something which is absurd? Then why this appeal is there? No, you see, unless, you see, the legislatures, no, Mr. Aram, the legislative intention can be only gathered from the, what you call the preface, introduction, no, preface and introduction. If that is not clear, then harmonious construction of the provisions of the statutes. So as a whole, when these powers are granted under this specific head, refusal will be there. We can't interpret it in any other way. Otherwise, we'll have to interpret in saying that Order 39 will make it redundant appeal for most of the cases. No. No, we satisfy me today because this is because I'm not postponing anything. Because I always say, you see, Mr. Alam, I always say that the writing of law, which is judicial law, by pronouncement, starts from the trial court. The trial court passes an order which leads to an appeal or a revision, it goes to Supreme Court or the High Court, and then law is laid down. So the originating of law is by the trial court only. Now, this interpretation must carry some meaning. Otherwise, it would have not said 7(2) for a tenant. It would have removed 2 the tenant. No, I understand. Do you think legislature did not have paper? It could have said appeal under appeal by both the landlord and tenant under section 4 and 5, and appeal only by landlord in case of 7(2). It did have a pencil and did have a pen, did have a paper. No, we'll have to interpret it. I'll pass orders in chambers, but it will be against you because that's just to write something on legislative intention. That's permissible. Heard Mr. N. Alam, that will counsel for the petitioner, as well as Mr. B.D. Dekar, and counsel for the respondent. Next paragraph. This application under Article 227 of the Constitution of India is filed against the order dated 19/9/2022, passed by the London Municipal Number 2, Kanpur Metro. We don't have to say so much. Next paragraph. On a preliminary objection of maintainability being raised, the learned counsel for the petitioner seeks to withdraw this petition and to approach the learned the appellate court under the provisions of Section 8 of the Assam Urban Area Rent Control Act, 1972. First of all, he said prayer not being objected to stands allowed. Accordingly, this revision stands closed with liberty to the petitioner to move the jurisdictional appellate court under Section 8 of the 1972 Act. Oh, okay. The period, it is also provided that the period spent from 11/11/2022, comma, date of filing of this application till today is permitted to be raised as a ground for taking extension of limitation under section 14 of the Limitation Act, comma, 1963.
Yeah, I think 42 upgrade. Item 42 upgraded item.
Yes. Just a moment. In the appeal, where is the impugned judgment and decree? In the memo of appeal, where is the judgment and decree? In the memo of appeal, no, but this is something we can't interfere. Order 41 Rule 5 application would not be maintainable. You allowed a decree to come upon you on admission. So when there is an admission decree, it's a consent decree. In consent decree, why should I stay an execution? Can you challenge a consent decree? Can you challenge it? For that, you don't need an appeal. You will file an appeal for correction of the order of the what you call arithmetical calculation of the trial court. Impermissible. I don't know. It's for you to submit. Because my jurisdiction to touch the appeal is also there. Now, first of all, you see, you are asking the court to extend some time to pay the rent. That is your prayer. In order 41 Rule 5, do we have the time to extend the payment? When there is a consent decree, why should we exercise that?
Circumstances arising like this, unable to
In this court, I have repeated a sentence which I am going to say. I have repeated it for umpteen times. I don't know how many times I have given this statement. I'll repeat it again. You see, you are all aware about a month back, I was ill. For 3 days, I couldn't come to court. You are aware of it? I was ill, I had viral fever, I couldn't come. I went to a doctor. The doctor checked me up and says, sir, how you are living, you don't have a heart. He found my heart missing. Just before my, what you call, just before I like it, if I start passing an order, would it be lawful? Just because I like it. Mr. Roy Choudhury, whenever he speaks to me, he will say that he gives a particular reference that there's only one difference between him and me. He makes that comment. So just because I don't like him, will I pass an adverse order in his case? I'm just asking you, because you are an officer of the court. Just because a judge likes something, if he starts passing an order, would it be lawful? We are in a temple of justice. So it will be dispassionate. It will be dispassionate dispensation of justice. That's end the matter. That's end of the matter. Because you see, if you insist, I'll have to touch upon the. I'll have to pass some remark which will affect you in your merit in your suit, in your appeal against a decree on admission, which amounts to a consent decree. If you challenge it, I'll be compelled to make some submission, some observation there which may affect you. It would be better if you withdraw it. If you want to escape from any observation of the court which touches on the maintainability of your appeal. No. Observation will be against. I have told you what observation would be. It is your call to take a decision. I have told you what observation I'll make. I'm not calculating a trial court error in arithmetical error. I will not be doing it. Even if you make out a very good case, I will not be doing an arithmetical calculation to correct the arithmetical error of the trial court. For that, you'll have to read CPC. There are some provision there. What happens if an arithmetical mistake is there? You only have the trouble to read the CPC. So if it is there, why should they appeal? That's why I said that you take your call. You take a call or we pass on observation and it may affect. I'm just suggesting it may happen, may not happen. It may affect you in the merit of your appeal. Or Mr. K.U. Ahmed, counsel for the applicant, and Mr. N. Kothari, learned counsel for the opposite party. Full stop. The learned counsel for the opposite party seeks to withdraw this application. Praise the Lord. Matter stands dismissed on withdrawal. It's IA, huh? Appeal, you have appeared. In the appeal, you write, in terms of order dated, both sides are represented. In view of order dated 9/3/2023, list the matter for hearing.
Item 15.
এটা hearing আছে আমার main case টা। Appeal to 23 appeal. There's one more appeal আছে। Yes. After vacation. Okay. Both sides are duly represented. As agreed to by both sides, this is the matter immediately after answering for puja vacation. Interim order passed release stands extended till the next day policy.
Item 16.
Yes. You're there. We'll admit the appeal. Issue notice. Okay. Early appeal. Heard. Mr. Harduve, learned counsel for the appellant, and Mr. N. Barua, learned counsel for the respondent. For the private respondent. For the government, who is there? You're there for the government. Mr. T.R. Govel and the government advocate appearing for respondent numbers 5 and 6. Please just check up. So for the private respondent, for the state, the two state respondents. Appeal is admitted for hearing. This appeal under section 54 of the Land Acquisition Act, 1894 stands admitted for hearing by issuing rule returnable forthwith without requiring the applicant to take first steps, take steps as the private respondents in the state are represented. However, extra copies of the memo appeal be provided to the learned counsel for the respondents and the government advocate within 2 days. Next, the records be called for. List after 4 weeks. Okay, the registry shall reflect the name of G. Assam in the causes for listing the matter next. I'm not saying right now. You make that clear when the records come, because no, I don't know. You see, because the experience shows that with the LCR is not tagged, they will not send it. Same common LCR. Oh, achha, then list along with so and so. Give the numbers. Appeal 14 of 2017. Okay. Okay. Next also same. Respondent shall come to government.
Item 18.
Please speak loudly. I'm not getting you. No, whatever is the reasons I have, we are not, it's not required. Yes. No, you see, Mr. Sinha, I've already told you the reason. because we can't extend by the way of an injunction. We can't put a new state of facts.
My instruction is that on 10th, tomorrow, they are going to vacate me from the command. Just because the suit is pending, let me also be legal to vacate me forcibly. I have filed a suit for protection. Let us be considered. I may be evitable, but my initial entry into the premises was not illegal. If I hold on after 10, then also I have to be legal infraction by the use of law.
Where is the trial court order? (45). Okay, heard. Mr. MVP Sinha, counsel for the petitioner. Sorry, appellant. This appeal is directed against this appeal under order 41 rule 1 within bracket R CPC is directed against the order dated 2/8/2023 passed by the learned civil judge within bracket senior division Morigaon in Misje case number 34 of 2023 arising in TS number 30 of 2023. Issue notice returnable in 4 weeks. Requisite extra. The appellant shall take steps within 2 days for service of notice on the respondents by registered post Delhi. To stop the pendency of this appeal shall not be a bar for the learned civil judge within bracket senior division, Morigaon, to proceed with the adjudication of Misje case number 34 of 2023. And IE civil. Mr. MVP Sinha and counsel to the applicant. Next, this is an application under order 39 rule 1 and 2 CPC, read with section 151 CPC. By which the applicant has prayed for waiving notice under Rule 3 of Order 39 CPC and to restrain the opposite parties from disturbing peaceful occupation and possession of the suit premises by the applicants. Stop. It is observed that the learned trial court had issued notice on the respondents Respondents of opposite parties. The order dated 2/8/2023. It appears that in the proceedings of Nijje case number 34 of 2023, arising out of TS number 30 of 2023, the respondents has already appeared. And the case was fixed. The case has been fixed on 2/11/2023 for written objection and hearing. On petition number 615 of 2023, be that as it may, as the respondents have already appeared before the trial court, this court does not find any good reason to pass an order of injunction, ex parte additive injunction, which would amount to a parallel adjudication of the prayer for injunction before the Illinois trial court as well as before this court. Full stop. Next, therefore, court is inclined to only issue a notice on the respondents returnable in 4 weeks. Petitioner shall take steps, applicant shall take steps within 2 days for service of notice on the respondents by registered post within this after 4 weeks. I'm not granting an injunction. You see, in the trial court, I've given my reasons why I'm not doing so. I'm not doing so. No. There's already a date fixed in the trial court. You can file an application for what you call predating the date and taking it up. No point this court adjudicating parallelly. Order 31 Rule 2, 1 and 2 will be pending before 2 courts. In trial court, when the defendants have appeared, and also before this court, why should we pass an order? But you see, for 2 months you have not been evicted. Correct. You know what to do. You're not a small what you call a petty trader. No. We know. You see, although I don't know anybody of this profession, but when somebody says that I am a brick clean industry, we can presume what he would be in actual life. No injunction. I am not granting an injunction. If you want, I can give a refusal of injunction. You will have again a right of appeal. If you are happy with that, I'll be in fact eager to do it. No, you have two choices. Third choice I have not given. One is this order. Second choice is that I reject it. So you get a right of appeal, which the other side will lose. No. Yes, Mr. Pathak, I've seen you patiently waiting for a long time. That election matter. Just give that record. 39. Yes, Mr. Bhuya, last time you were saying something in this matter. Three zero? It's not here. Oh, 3087. Ah, yes. What is you want to amend? What is the present application, present para 39?
The last order of the COVID order, you want to bring on.
Yes, should we issue notice or it can be allowed? No, it's okay. That's why I'm asking you.
Let it be allowed, because 27/4/21,
That you already brought on record.
they have already annexed. Now they want to bring the last order of the COVID.
That you have produced on the exit.
If your lordship, there is nothing wrong, and the lordship can allow the amendment.
Okay. Heard. Mr. Andy Bhuya, learned counsel for the applicant, public electrician petitioner, as well as Mr. K.B. Pathak, learned senior counsel, assisted by Mr. A. Barua, counsel for the respondent, number one. This is only one respondent, opposite party. Next para. This interlocutory application has been filed in order 6/17, read with section 151 CPC for amendment of para 39 of the connected election petition. Next para. In this regard, the learned senior counsel for the opposite party has submitted that by the said amendment, the applicant seeks to bring on record the copy of subsequent order of the Supreme Court of India dated. What is the date of the order? 10/1/2022. He has submitted that on the last occasion. He has already provided a copy of this said order before this court. Full stop. Next paragraph. As it appears that the nature and character of the pleadings made in paragraph 39 would not be altered to the disadvantage of the, no, would not be altered.
Registry have referred to this order.
No, it's that's why I'm just formulating the would not substantially change the pleadings. Would not substantially change the pleadings, comma, this prayer made in this application stands allowed. Taking note of the fact that the ratio of this court while calculating limitation has taken into account this at order. Full stop. Accordingly, the this application stands allowed. And then in the in this appeal, you write, Mr. Andy, we had a counsel for the petitioner as well as Mr. K.P. Pathak, senior counsel, assistant Sai Baba, counsel for the respondent. Next para. In view of the order passed today in IA Civil 3087 of 2023, comma, the petitioner shall submit a copy of amended plaint within a period of 14 days from today, with copy thereof to the learned instructing counsel for the respondent. Full stop. On such amended petition being filed, comma, the registry shall keep the same on record. Next para, list on where
I understand the last week before 2018.
will be a very hectic time. For us, it will not be happy hours. Mr. Bhuya is your son? Okay. Good to see a second generation here. Ninth November, let me ask Mr. Das, 9th November? Or this one, 9/11/2023. So there are interim other applications.
Another I seeking time or seeking for hearing of the order 7,
Rule 11.
order 7 rule 11. That has not started. I have not started order 7 rule 11. We in 1984, another I, which is in the midst of hearing, they have not filed any objection. That is related to order 14 rule 2.
For preliminary issue
Whether the
of maintainability, but by limitation.
that the hearing was already on. Neither they have filed objection, nor they have filed any IA seeking time today. So now, my lord, that is, since my part was over, so there is no IA from their side.
No, Mr. Bhuya, this election matters, you'll have to take note of every application which is there. You'll have to, there's a requirement to file an adjournment petition. Because 3088. This is in which application? One 1982. What is this 1982? 1982 is order 7 to 11. You are currently
In 1984,
1984.
yes, this was the hearing was held. That was regarding order 15/2000. And we were asked to file objections, there was no filing.
So, Mr. Bhaiya, you have to make your submissions or we have to close it. This is for an framing of an appropriate preliminary issue. Then what we do is, no, you don't have to file a separate wakalatnama. In this, a notice was already issued,
Then objection was not filed.
but objection was not filed. And hearing is started in this matter. This is to,
Last occurrence also, when I was calling the.
we granted opportunity to the young counsel, but she did not avail it.
But he asked him to talk to me. And newly and the last time, the oral submission was made, then I say that this is not the way because of section 87 requirement, your lordship also. Today also I find no objection filed, no time.
No time. So you can't do, you have to close this matter. Here the submission of Mr. Pathak is that notwithstanding the Supreme Court order extending limitation, since this being an original application, the extension of time would only be for the purposes of existing applications or an appeal, which does not include a fresh suit. For that extension of time, extension of limitation is not never granted. That is the argument.
Even if it is counted from calculated from 1st of March 2022, that also is gone. Break up five, that also actually. Every reporter has said that there is 263 days after that he has filed, 213 days is the delay. So it is deemed to be condoned. Actually, he should not have written like that.
No, you said on that day, because it will be a judicial,
It's a judicial.
judicial, it should be a judicial order. No, but you'll have to make a note. There's no escape in this election petition. These are too technical. Because your application for being on record, the additional document would also would be taken away by this argument of Mr. Pathak, if we accept it.
That's why I accepted it. Let
No, but what to do? You'll have to make preparation and make an argument. You can at best spill it up for tomorrow. No, time like that we can't grant, because it's only spilling it over means that today, since we can't take it up for the positive time, it spills over tomorrow. The adjournment is something we can't grant without an application being there. So tomorrow, make your submissions. Due to 1/7/1 due to positive time matter could not be taken up today, hence the matter spills over to tomorrow is 10/10/2023. On which date the learned counsel for the opposite party will make his submissions. If required, you take note of whatever applications are there, because you may be at you may be taken off guard. You may be taken off guard. You just check the records. It will be necessary. Otherwise, you will be caught unawares. But it's good to see second generation here. It's good to see a second generation here.
Welcome our young generation.
That's why I said. That's why.
This institution will survive on them.
If they work hard,
They have to. They have to.
they have to. Yes, Mr. Rajavi. 35. Just tell the court master we'll be getting it extended. Mr. Prakash, you'll have to button down your coat first. Yes. Yes. '21. Just wait for some time, we'll take it up. Just wait for some time, we'll take it up. Item? What is the matter? Okay, 48, give a date after vacation. 48. Give a fixed date.
21.
Okay, the court master will give after some time. 48, huh? Fixed date after vacation. Yes. Well, what is the matter? 43? Is for early hearing. No, the court master will give a date. I will not give it. 43 also, give a date. Okay. Item 19. Yes. What is this? Challenge is injunction order. Just wait for some time. We hear this. What do you call this? Item? No. One more item. Mr. Prakash said trade. After this, I'll take it up. 21. After that, we'll take up your matter. Any other mention? If not urgent, please give it to the court master. You filed additional affidavit. It's not there. Item number 49. Counsel for the petitioner submits that an additional affidavit has been filed, which is not on record. The same be tagged on record. List immediately after the ensuing vacation. Okay, interim order passed to list and is extended till the next date of listing. Okay.
Number
46, 47. Okay, just wait. Two matters, I'll take it up after then if I have time. Tell the court master. Yes, Mr. Prakash, sir. Just a moment. You are the plaintiff or the defendant? Suit was decreased against you. First appeal also decided against you. Dismissed on ground of delay. Okay. Where is the petition of yours explaining the delay, and what is the order of the court? Which page is your petition? No. Where is your petition where you said that you are assigning reasons, and what is the order? Which page is the petition? Which page is the order? Pardon me? 22. Page 22. No. 22 is something, paragraph 14. Additional affidavit. Page 14, yes. 22. Now, where is your petition? First, where is this petition where you refer to illness and then the order? No. You see, the first appellate court dismissed your application, rejecting your contention. Where was that contention? Where do you find that statement before the first appellate court? Hundred 35. But Mr. Prakash, sir, you see, second appeal can only be admitted on substantive question of law. The trial court rejected your petition because of your own certificate. Its certificate says you were given treatment from time to time from 28/5/19 to 17/3/2020. So from time to time, how should we interpret the second appellate court? How should we interpret it? But this is perfectly right. You are not ill for the entire time. You don't get period of extension of time for limitation. Okay. Page 22. Page 22 is the order of this court. We are aware of it. You are relying on these prescriptions and the medical certificates. Did you cross check? What is what is the illness and what are the medicines for? Did you cross check? But these prescriptions do not help you. It's not related to. It's not related to what you are saying. Oh. That's all. Pardon me? What is the decree in the suit for? No issue for? No, that issue is never required in a suit, because when a title is claimed, Therefore, and if the court has framed the issue with regard to the right in respect of Schedule A within bracket 2 land, that is good enough. No, that will depend on the nature of pleadings made. I have not read the pleadings. You see, number one, X has you see, there are two people, A and B. Both claim to have purchased the suit land by way of a sale deed. Correct. Now, the question before the trial court here, according to this issue, is whether the plaintiff has a right title interest over the Schedule A2 land. Correct. Where is the requirement of what you call making an adjudication which sale is right or wrong? Because the court will give a finding on regard to your title. So a title, it will say that the sale deed of A is valid, and therefore he has got title, or the court will say that B has got better title, and therefore A suit will be dismissed. What is the requirement of framing an issue on the? No, Mr. Prakash, please understand, the question I am asking has some relevance because of the fact that you had an opportunity under Order 14 Rule 2 to, or the other provision 4 or 5, to have the issues altered. You did not do that. No. You are saying that the issue was not framed. Now your argument is that issue was not framed. What I'm asking from you is that you got an opportunity of having the issues altered. You did not do it. At the second appellate stage, whether the issue was rightly framed or not, it is a substantial question of law. No, whatever be, that will adjudicate. But the problem is that you see, issue is not framed is not a substantial question of law. Huh. Yes. No, you see, that will come when we adjudicate it. Well, you see, come to page 103 of your memo appeal. The court has given its reasons. From there, then issue number 6 is decided. Issue number 2 is at 105. No, why not? If it is perverse, you can definitely raise in appeal. Yes. No, admission, we are hearing a matter for admission. Because Mr. Prakash sir, we are here in second appeal, number one. Number two is that it transpires from the materials available on record that no DW was examined and no defense evidence was led. So therefore, what substantial question of can I frame? That's why I'm asking you. You have preferred. You have shown us the what you call the prescriptions. Number one, are you aware of what disease the patient was suffering? And number two, have you considered what medicines are prescribed? I'll tell you because I've got some interest in medicine. It's an alternative profession. I would have equally done good quackery. I'm here, otherwise I would be in a good quack. You see, as per the prescription is suffering from general anxiety. Correct. General anxiety. Now, for general anxiety, incidentally, out of 5 drugs which have been administered, 3 are for stomach problem. Your tablet BPIDS D. This page 28 of your affidavit, that's what you showed us. Ofomac OZ. And this Rifampin syrup. Hyoscimix, I couldn't find out. What was that? This was stomach disorder. Gastrointestinal reflux. For that it is given. Gastric, just tell me, out of 10, 9 people will be suffering. No, but I must understand, you see, for mental treatment, this is a general anxiety is a mental disorder. For mental disorder, if doctor prescribes what you call medicines for gastric, no, I can do one thing. I can write something in the order which will give you a handle to sue the doctor. No. We can't keep it pending. This is already pending for once a year. Not heart disease. Is a male or a female? Female. Okay, this Hyoscimix I could get it. It is for menstrual pain. So can't help it. No. No. We won't allow that. No, Mr. Pukasta, we have taken up the matter after the court has not to adjourn the matter. No, we'll pass orders in the chambers. It will be dismissed. So what else you can do? You see, unexpectedly, the second appellate court is looking at your prescription. I have gone into the facts. Second appellate court is not required to go into the facts. I have gone into the facts. I have given you out of 5 prescriptions. 3 are for gastric, 1 is for menstrual pain. And if that constitutes mental anxiety, for which you are intermittently in treatment, no, it's a mental disorder. It's a recognized mental disorder. Yes, if you will get it better when you go to Tejpur and ask someone, specialist there. No, because you are intermittently and you are giving gastric treatment. Mental disorder patients, I have hardly found this prescription. That is why it prompted me to look into the drugs. No, we can't entertain more than this in second appeal. No, we can't help it. I'm just, I'm not passing. Okay, let's pass the order. Otherwise, you will think that had Mr. A.K. Purkasta counsel for the appellant. No. We can't permit that. It will lead to what you call manufacturing of documents. No, Mr. Purkasta, this is something we can read. Had I not been able to read a prescription, then it's something else. But this is something I can do. We don't need a better document in second appeal. No. I have. You don't worry about that. I can take care of your lack of knowledge. Medicine is something I know it like back of my hand. You may not realize, but whenever I have time, I read medical. I do it just for fun, because I don't what you call this. All this seriousness has led me to read medical. Because when you say medical disorder, it creates a what you call counsel for the appellant. Next paragraph, this appeal. This is an appeal under section 100 CPC. Full stop. The appellants are the defendants number 5 and 1 respectively in the suit. First of all, the suit was dismissed by decreed in favor of the respondents, plaintiffs. Respondents number 1, 2, and 3 plaintiffs. While impugned judgment and decree dated 29/5/2019 passed by Learned Musif number 1, Morigaon, in TS number 3 of 2015. They were declaring a right, title, and interest over the suit land described in Schedule A within bracket Roman 2 of the plaint, and declaring recovery of khas position of the suit land by demolishing the structures and by decree of permanent injunction and the counterclaim filed by the respondent number, the appellant number 1 and defendant number 6. I can't get it. Also, no, appellant number 1, sorry, appellants as well as other defendants from defendant number 1 to 6. Full stop. The appellant preferred in first appeal before the learned civil judge Morigaon against the decree passed by the learned trial court. Stop. However, by rejecting the application for condemnation or delay being Miss J case number 26 or 2020, resultantly the first appeal was also dismissed. Next paragraph. The case of the respondent numbers 1, 2, and 3 in the plaint is that the land of their predecessor in interest, late Abdul ABDUL Kalim KALIM, was divided between his two sons, namely Abdul ABDUR Rahman RAHMAN and Jaynaluddin JAYNAL Uddin UDDIN, by virtue of a family settlement. The share of late Jaynaluddin is described in Schedule A within bracket 2 of the plaint. Full stop. It is projected that while alive, Abdul ABDUR Rahman sold the land described in Schedule A within bracket 1 to the defendant numbers 1 and 6. And that in the month of October 2014, an attempt was made by the defendant numbers 1 to 15 to occupy the Schedule A within bracket 2 land. And accordingly, the suit was filed with prayer for a decree or declaration of right of the plaintiffs over the Schedule A within bracket 2 and Schedule B land, recovery of khas position of Schedule A within bracket 2 land, and for confirmation of possession over Schedule B land. With prayer for injunction and cost of the suit. Next, the defendant numbers 1 to 6 had contested the suit by filing a common oblique joint written statement as well as a counterclaim by the substituted defendant number 2. Being defendant numbers 2 within bracket 1, numerical, Roman 1, TO2, 2 within bracket Roman 5. Clearing that the predecessor Abu Rahman, ABUR at least, had no son or daughter, for which Abdul Rahman, ABDUR, Abdul Rahman, and his brother Joinaluddin, while alive, partitioned the entire Sud Patta land between them. Full stop. It was claimed that Joinaluddin, while alive, sold 4 bighas of land to one Muhammad Sabdul, SABDUL, and Muhammad Forjul, FORJUL, Hawk. And further sold 3 kathas out of remaining 1 bigha 1 katha land. But still deed number 4754 dated 4/5/1976. And 4 kathas of land was sold by Abdul ABDUL Rahman to the principal defendant number 1, Muhammad Fazlul, FOZLUL Haq, and defendant number 6, Muhammad Nazrul Haq, by sale deed number 3176 dated 23/1982. And further land was sold by Joinaluddin. Further land measuring 1 bigha 2 katha was sold by Joinaluddin to the defendant number 1, Fazlul, FOZ, Muhammad Fazlul, FOZLUL Haq, by sale deed number 1084 dated 4/9/2001. And further land measuring 2 katha 5 lacha was sold by Joinaluddin to again Muhammad Fazlul Haq on 15/1/2002. So it is claimed that the land purchased by the defendant number 1, 2, and 6 were duly mutated in their respective names. Full stop. It was claimed that the Sud land described in Schedule A within bracket 2, Roman 2, and Schedule B was purchased by the principal defendant numbers 1, 2, and 6, out of which Schedule A within bracket 2 not so right sale deed number 4754 dated 4/5/1976, as well as cell deed number 3176 dated 23/1982. Under the journal JOYNL sold his remaining land of Dag number 126 to the principal defendant number 1. So it's claimed that the plaintiffs were permissive possessor of the suit land described in Schedule B and did not vacate the suit land on demand. And the present suit was filed. Accordingly, the counterclaim, it was pleaded that the right title and interest over the Schedule B land and the counterclaim of the contesting defendants, as well as first son of the deceased, Sabdul, SABDUL, namely Mohammed Nurul, NURUL, Amin, for degree of confirmation of possession of the land described in Schedule A1 and A2 of the counterclaim, and for degree of khas possession of the suit land by evicting the plaintiffs from the suit land for cost and precept. Next paragraph. It transfers from the record that the plaintiffs filed the written statement against the counterclaim, denying the statements made in the counterclaim. Full stop. In course of trial, the plaintiffs has examined 3 witnesses, namely Javed Ali, JBED, within bracket PW1, Abu Samed, ABU, SAMED, within bracket PW2, comma, which was not considered, and Mohammed Hafaz AFAAZ Uddin, within bracket PW3, and exhibited the following documents. Page 111. Give the document number first and then within bracket exhibit A 1, 2, 3, 4, 5. First, the defendants did not examine any witnesses and no exhibits were proved. First, the learned trial court had framed the following issues for trial. This is page 101. Para 12, para 13. Flag. No. This is say para 16, huh? Page 103. First, in respect of issue number 1 and 6, it was held that there was counterclaim for there was cause of action for the counterclaim. For the suit as well as counterclaim. In respect of issue number 2, taking note of the evidence of the plaintiffs on record, as well as their pleadings, the on the basis of exhibit 1 and 2, it was held that that Abdul Kalim, ABDUL Kalim, was the original patadar of the suit land described in Schedule A and B, and as per note K of exhibit 3, it's held that the mutation is made in the name of Abdul ABDUL Rahman and Jainal Uddin, and as per note Kha of exhibit 3, the name of Jainal Abedin was mutated in place of Abdul Rahman by way of inheritance. And as per note Go of exhibit 3, in place of dag number 124, the dag numbers 37, 38, and 39 were entered. And as per exhibit 3, the name of Abdul Samed, ABDUL, Samed, SAMED, and Javed Ali were mutated in place of his father as against the name of his father, their father. And in view of law of inheritance, it was opined that though the name of Jahera Khatun, Jahera Khatun, does not appear in exhibit 3, but it does not extinguish her right over the suit land. Therefore, as no evidence was tendered by the defendants, issue number 2 was decided in the affirmative, and resultantly, in respect of issue number 2, the plaintiffs were found entitled to decree for recovery of khas position, confirmation of position, khas position over Schedule A within bracket 2 land, and confirmation of position over Schedule B land. And it was held that the defendants had dispossessed the plaintiffs from the Schedule A within bracket 2 land, and also threatened them for eviction and disposition from the Schedule B land. So accordingly, issue number 3 were decided in favor of the plaintiffs, and the plaintiffs were found entitled to the decree as prayed for. And in absence of any evidence, the counterclaim was dismissed by deciding issue number 8 and 9 against the defendants' counterclaimants. According to the suit was decreed, declaring right title interest of the plaintiffs over Schedule A within bracket 2 land and Schedule B land, the plaintiffs were found entitled to recovery of khas position of Schedule A within bracket 2 land by evicting the defendants and by demolishing their structures, and in respect of the said land, the plaintiffs were restrained by way of permanent injunction from entering into the said Schedule A within bracket 2 land, the 2 and B land in future, or from disposing the plaintiffs over the said land. Next paragraph. As already indicated above, the appeal was filed by the appellants with some delay, and for condition of delay, the application under Section 5 of the Limitation Act, read with Section 151 CPC, was filed, which was registered as Miss Case number 26 of 2020. Mr. Sensor and Mr. Iqbal, I don't think I'll be able to take up. This will take about 10 minutes more. I'll take it up day after tomorrow. Friday, okay. Okay. His matter, Wednesday and his Friday. Okay, just to the court master.
Item 19.
For
Friday.
continuing a delay of 532 days in preparing the appeal. Stop. It appears that the present appellants are defendant number 1 and 6. The defendant numbers 1 and 6 have heavily relied on the medical certificate and prescription of treatment of the appellant number 1, Musamat MUSSTT Sarifa SARIFA Khatun KHATUN, dated 7/3/2020, given by a particular doctor within bracket annexure 2, and another prescription given by another doctor within bracket annexure 3. Full stop. The set to prescriptions were discarded by the Learned Trial Court by its order dated 11/2/2022. The two medical certificates as well as another doctor's prescription were discarded by the Learned First Appellate Court by order dated 11/2/2022. On the ground that that out of the 3 prescriptions, 2 prescriptions were issued in the year 2016. And another prescription appears to be issued in the name of said Musamat Sarifa Khatun, but it does not bear the signature of the doctor who had issued it. Full stop. The medical certificate disclosed that the said Sarifa Khatun was given medical treatment from time to time since 28/5/2019 till 17/3/2020. Accordingly, the court had opined that the medical certificate showed that the Musamat Sarifa Khatun the appellant number 1 was not ill during the entire period. First off, it was also, the court was also of the considered opinion that the appeal was preferred by 2 appellants, namely Muhammad Sarifa Khatun and Fazlul, Fajlul Haq, but no ground has been shown as to why the second appellant could not file the appeal on time. Accordingly, the ground of delay could not move the court to justify to justify condoning the delay of the delay that occurred in filing of the appeal, and accordingly the application for condonation of delay was rejected and resultantly the appeal was dismissed. Full stop. When this appeal in course of consideration of this appeal, this board court by order dated 7/11/2022 granted leave to the learned counsel for the appellant to obtain instructions and to file documents by way of an affidavit. Full stop. Accordingly, by filing an additional affidavit on (21/9/2023), the appellants have filed a medical certificate, a copy of the medical certificate dated 7/9/2020 by the Deputy Superintendent, Lahori Ghat, LAHARIGHAT, Lahori Ghat Model Hospital, District Morigaon, certifying that Mrs. Sarifa Khatun aged 40 years, wife of Fazlul, Fazlul Haq, of village Daliabari, DALIABARI, Lahari Ghat, LAHARIGHAT, Morigaon, is a case of neuro, NURO, LS, and hepatitis. And under treatment since 28/5/2019 from time to time. And that she needs further treatment and investigation. First of all, no prescription are filed in support of the said certificate to show that the appellant was under treatment from the concerned doctor whose name is masked in this, is not disclosed in this order. Stop. In the second medical certificate produced, which is a certificate from the concerned doctor who's a neuro psychiatrist, NEURO. Next word is psychiatrist, PSYCHAI CHIA TRIST, PSYCHIA TRIST at Nogam, who had certified that the appellant number 1 had been suffering from generalized generalized anxiety, ANXIETY disorder, along with migraine problem, and was under his treatment from 28/5/2019 and 17/3/2020. First off, from the said certificate also, it cannot be said that the appellant number 1 was under constant medical treatment. Full stop. In the copy of prescription enclosed, which was by the doctor who had given the first certificate, within bracket page 24 of the additional affidavit. No, don't read that. Prescription is enclosed page 28 of the additional affidavit, which is by a third doctor. No, it's a medicine purchase invoice, not a prescription. Medical purchase invoice of a respondent of the appellant number 1, which is prescribed by a third doctor. The first of the invoice is dated 15/3/2022. Full stop. Out of the 5 medicines prescribed, BIPAZ D capsule is for treating gastrointestinal GASTROINTESTINAL reflux REFLUX disease. The second tablet, the second drug, Hyoscimax, HYOCIMAX MF tablet, is generally used for treatment of menstrual, MENSTRUAL pain. The third drug, IVORAL FORTE tablet, is used for treatment of parasitic, PARASITIC infestations, INFESTATIONS of skin, hair, scabies, inflammatory disease, pediculosis, PEDICULOSIS. Full stop. The fourth drug, Oflomac, OFLOMAC, next word OZ tablet, is used for treatment of bacterial and parasitic infections. Most of the use of fifth drug rifamin, RIFAMIN syrup could not be found out. Most of therefore none of the drugs which are prescribed by the third doctor within bracket page 28 of the additional affidavit is for use of curing generalized anxiety disorder with migraine problem, which is certified by the second doctor at page 27 of this application of the additional affidavit. Stop. Next paragraph. Therefore, comma, this court is of the considered opinion that the learned first appellate court was justified in rejecting the application for convention of delay on the ground that the prescriptions do not indicate, the prescription of appellant number 1 do not indicate that she was under constant medical treatment, because the first certificate itself demonstrates that the respondent number 1 was availing treatment from time to time. Next paragraph. Moreover, comma, as the appellants had not reduced any evidence before the learned trial court, comma, it cannot be said that there was any perversity on part of the learned trial court to appreciate the evidence on record, or to misread or misconstrue the documentary exhibits. So therefore, on all counts as indicated above, comma, the court does not find any substantial question of law for admitting this appeal and for admitting this appeal. So accordingly, this appeal stands dismissed at the admission stage without issuance of notice on the respondents. Next paragraph. The formal decree of dismissal of this appeal be prepared, and this order of the court shall be transmitted by the registry before the learned courts below for retaining on record.
It will 19 or 1946, 47.